Just press the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started on this early edition show. It is a Friday, and we do have some interesting business to attend to. We're going all in on the Kari Lake trial, but we can't just start jumping off until things are working, especially this early. You know, sometimes it takes a minute or two when things are this early over here, although it's not that early anymore. But it looks like things are alive and well, and so let's go ahead and get started. I heard something which sounded like a Zoom meeting or a Microsoft Teams meeting. So we're checking in on Kari Lake, and we're moving the screens around, and this is what I'm seeing right now, just so you know. We've got a blank screen, but court is not supposed to start for another 5 minutes or so. But we just heard some audio come in, sounded like the Teams meeting was filling in. And so as we wait for court to get into session, let's take a look at what is on the docket today. We have the big update. Today is oral arguments. Of course, Kari Lake has several claims. She's alleging that the Arizona election in 2022 was conducted with significant malfeasance, and they had a previous status conference. Remember, this case went all the way up to the Arizona Supreme Court, and they sent it back down on one particular charge regarding signature verification, saying that they did not go through the proper modalities in order to certify the equipment and other things. So the judge said, all right, here's the deal. We have to submit a bunch of documents by Tuesday through Thursday, which was yesterday, May 11th, and then ordered oral argument to be scheduled today, right now, 9 a.m. The time to be allotted would be 4 hours, and so we've got just about 4 minutes until that gets started. Oral argument, public service announcement. The oral argument will be live streamed, so the public should view it on that connection. All right, so we should be watching it on this connection. And this came over courtesy of our friend N810 on Locals. If you go to the Maricopa County Superior website and look at the calendar, you could take a look at today's calendar and just join on the live stream if you want to watch here, presuming that this works. But the judge is just recommending that we use that rather than use this feed. Remember last time people were using this tiny URL. That is the court's URL only, and it was bombarded. I think this was before the trial. So the judge is specifically saying this link is only for the parties, so don't hop on that link if you are wanting to watch it. Instead, go to the court website and watch it there. Uh-oh, you hear that? We got some activity. It's like a sci-fi novel. Just bursting with anticipation. What's going to happen here? So that is what is happening. And it should be, they say today, about 4 hours. So we'll see how long it goes. 4 hours is, that will bring us right into the lunch hour. And there's a ton to talk about. I'll give us a quick refresh here in a second. But the trial is going to be scheduled next week, May 17th. So we'll have a 3-day trial. I'm going to guess the whole thing is going to be live streamed. And if there's interest, we'll just stream the whole thing because it's going to be, well, I think it's one of the most important things happening right now. Remember, Arizona is one state of 50, but it's a pretty important state. If Arizona continues to go blue, as they say it does, then that's not good for the country, in my humble opinion. So it's a little bit of a canary in the coal mine. You know, if Arizona falls repeatedly and some of the shenanigans that we think are going on here are not addressed, then the dam may be bursting. We've got activity in the courtroom. I hear some sounds. We're checking in. This is the court feed directly from the court. We still got 3 minutes away until the court gets going. Now, just as a refresh, now we've got a video on the channel coming out here very soon on this. We talked about this yesterday on our members segment, our members only stream. But this is the latest filing from Kari Lake. They're still banging around back there, setting the mics up, setting the cameras up. Kari Lake filed this, and this was a pretty shocking filing. They alleged that in Maricopa County, they've got new and compelling evidence that shows that Maricopa County, this comes from Kari Lake, falsely certified the testing, certified the equipment, knew they hadn't tested it. Then after the date that they signed the certification, they went back and secretly tested all of the vote center tabulators on 14th, 17th, and 18th.
Can I please have the name of the person that just called in under the last 4 digits, 4600?
Not us, Judge.
William Stein, S-T-I-N-E.
S-T-I-N-E?
Correct.
Thank you, sir.
Yeah.
I know. Can I ask what your relationship is to the case?
I'm just a interested citizen.
Come on YouTube.
Okay, you need to hang up and go watch it on the live stream.
Come on YouTube, bro.
The Maricopa County live stream.
Is that the www.
Watching the Watchers. Come join us.
YURL.com.
No, it's www. It's maricopa.gov.
Maricopa.gov. Okay.
Okay.
I will
Thank
try
you,
that.
sir.
Thank you very much.
You're welcome.
Hey, thanks for paying.
Thank you.
Thanks for calling in, Stein. We appreciate you. Thanks for your interest. Thanks for being interested in this. Okay, we appreciate it. Tell your friends.
Are we still waiting?
Okay.
We are, Judge.
Okay, that's fine.
Is this on video? Hang on a second. Let me make sure that.
This is CV 2022-09-5403. This is Kari Lake versus Katie Hobbs et al. And this is the time set for oral argument on the 2 pending motions.
I'm not getting video. Are you guys getting video?
This was set to start at 9 o'clock. I've been waiting because I've been told that the live stream link for people who would like to observe what's happening here today, but we've asked not be admitted to the courtroom for logistical reasons, which the last time we did this precluded even you and your clients from attending. That link is not yet clicked on functioning, well, that it's supposed to be momentarily. So in the interest of, I guess, having the live stream function, I'm not going to sit here and stare at you until the IT people complete their functions. So I'm just advising you what the status is. I'm going to go off the bench until I hear. If this is not a reasonable period of time, I'll just have to make a game time decision with regard to that. Do either of the parties object to proceeding this way?
No, Your Honor.
No, Your Honor. No, Your Honor. Okay. All right. Then I'm going to go off the record. I'll be back as soon as I get some kind of indication that we've got that functioning, okay? Or a reasonable period of time. Otherwise.
All right. All right, please be seated. Okay. So, some preliminary matters that we're going to attend to.
Mr. Mast?
Yes,
Hi, are you affiliated with the Lake case?
I'm the amicus curiae party.
He is.
Okay. Okay. Thank you, sir.
Okay, so
Victoria, this is Carlos from CTS. Can you hear me?
Yes. Is it working? Are you seeing that it's working?
Or Ron, can you hear me, Ron?
Okay, so as they're getting set up, let's keep tabs on that. Let's check back in and go.
I wasn't seeing it on the webpage. I will let the judge know. Thank you.
Thank you.
Okay, let's go back over and take a look at the motion that Kari Lake had submitted. And this is, okay. All right, this is the motion. Now, I wanted to just highlight this. Kari Lake is saying they've got new and compelling evidence that shows, among other things, Maricopa County falsely certified its equipment. They said it was certified. They said it's good to go into the election. After that, after they signed the document, they secretly tested all of the tabulator centers after the certification date, knowing that 260 of the vote centers would fail on election day. They also have got new evidence that we probably are going to hear about today, or at least hear about what the procedure for arguing the evidence will be at trial next week. But they're going to prove or show that Scott Jarrett gave false testimony, the guy who took the stand at trial concerning the printer failures. And we went through this motion at length. We've got a full video coming out on this. We really spent some time on it. But something that's pretty shocking in this whole thing.
All right, I'm told one of the attorneys just momentarily stepped out. We'll just hold off for a second here.
One of the more shocking
There we
things
go.
here is that who was in charge of certifying all of the things?
I had to blow my nose.
Oh, yeah, Katie Hobbs. She was the Secretary of State. So she's the person, her office is the entity that
All
is
right,
making
we are
sure that all the rules are
Proceeding in
being
CV
followed.
2022-09-5403. This is Kari Lake versus Katie Hobbs et al. And this is the time set for oral argument on the two pending motions in this case. And what I will do is begin by having appearances for the record by the counsel involved. We will begin with petitioner, Mr. Olson.
Kurt Olson for plaintiff Kari Lake, Your Honor.
Thank you. Mr. Blem.
Brian Blem for plaintiff Kari Lake. Thank you, Your Honor.
Mr. Morgan.
Good morning, Your Honor. Craig Morgan for Sherman and Howard on behalf of the Secretary of State. With me in the courtroom are my colleagues Jake Rapp and Shana Stewart.
Thank you. Mr. Ruiz.
Good morning, Your Honor. Joseph LaRue on behalf of the Maricopa County defendants. With me in the courtroom are my colleagues, Joe Branco from the Maricopa County Attorney's Office and Emily Krager, who is outside counsel on this matter.
Thank you. Very well. And appearing remotely.
Good morning, Your Honor. Ava Khanna on behalf of contestee Governor Katie Hobbs.
Okay. And Ms. Khanna, can you see and hear all that we are doing in the courtroom?
I can, Your Honor. Thank you.
We're able to see you as well. All right. What I had anticipated doing here is the same as we had done with the previous motions that we had heard for oral argument, breaking the time up equally between each side. And that would be, if we use an hour for oral argument for both of these, then each side would get 30 minutes of that time to be divided up with, well, for plaintiff, whoever's motion it was would go first. You can reserve whatever time you want out of your half of that and then have the final word, or you can just do all of it up front, whichever you choose to do. And as for the defendants, you can elect, because there's three different persons, you can split it up and each of you take your pro rata share, or you can designate somebody to be the person that's going to take all that time.
Yeah, because
Okay?
there's three different defendants.
So-
You got Board of Supervisors, Katie Hobbs, and you've got I think Maricopa County. You got the Secretary of State and Katie Hobbs. So you've got all these different defendants.
Okay,
So
Mr. Mast?
who's going to go first?
Yes.
Okay. Can you mute your microphone? Because I think there's background noise that's coming through. Thank you.
Can you hear me now?
I don't know. Excuse me. Are you Mr. Mast?
I am, yes.
Thank you. Okay. All right. So, with regard to the motions, let's deal with the motion for relief from judgment first.
That's the one we were just looking at.
What?
Your Honor, I'm sorry. Before we get to the motions, there's at least one housekeeping matter that I'd like to take care of, if that's all right.
Katie
Sure.
Hobbs' lawyer.
I inadvertently misrepresented something to the court. Mr. Blem alerted me to it this morning. In the county's response opposing Mr. Mast's amicus brief, we wrote that Mr. Mast sought the permission of plaintiff Kari Lake, but did not seek the permission of any of the defendants. I based that on footnote 1 of Mr. Mast's actual amicus brief, where he says petitioner consented to the filing, but the defendants did not consent. And I knew that none of the defendants had been asked. I assumed when he said that petitioner consented, that meant he had asked petitioner. Mr. Blem informed me this morning that he was not asked. And so I wanted to set that record straight, Your Honor.
Thank you. Mr. Blem,
Good.
do you consent?
We did not consent, Your
Oh,
Honor.
no, not did you, do you?
No,
You don't want?
no, we had consented in March to one, but that's the only one.
Okay,
But then
so the
yeah.
parties are not interested in having the amicus brief.
we're not, Your Honor.
Are you?
The county is not, and I'll let the other defendants speak.
Okay, thank you.
Nor are we, Your Honor.
Thank you. I'll rule on that later. That was not set for oral argument.
Okay,
This
an
clears up
amicus
the
brief
matter
is a
of
friend
record
of
that Mr. Blem brought to the attention
a
of the
friend
other
of the
parties
court brief.
while you're here.
Somebody else submitted
Okay.
something. Nobody else wants it included. Do you want his
The motion
opinion?
for
No.
relief.
Do you want his? No. Do
That
you want
would
it? No.
be
Do you want it?
plaintiff's
No.
motion. So on that, for the 15 minutes, and what I'd like to do, counsel, I want to focus on what you're saying. I don't want to be up here being a timekeeper. This is not a chess match. So I'm going to rely on your integrity to try and govern yourselves, but with the other side keeping track, okay, for both ways on this, all right? Do you want to reserve part of the time for rebuttal, so to speak, Mr.?
I will, Your Honor.
And I'm looking at you. I don't know which of the two of you are addressing which motions, but
I'll be addressing both, Your Honor.
okay, how much time do you want for rebuttal on your motion for relief?
And you said that there's an hour total
Well, for both motions,
for both motions an hour.
yeah, unless you, let me specify something right up front. I've read everything that you've written.
Okay.
And reread it and thought about it and gone over it. So just with that background, I came in early this morning to make sure that I reread and went over the things that were filed late yesterday. So with that in mind, I thought that oral argument should be focused on, I don't believe anybody's going to tell me something today that they didn't put in writing, but it's maybe to highlight what you think is the most important, pertinent, salient points and go from there. So with that in mind, is 30 minutes per motion adequate for each of you,
I think it is, Your Honor.
for the defendants?
Yes, Your Honor. Thank you. Yes.
Very
He
good.
doesn't want a big,
So
long,
that would mean
drawn-out
on
thing.
this motion, the 30 minutes for the motion, and I'm not starting the time right now. The 30 minutes that we're going to spend actually arguing, that would mean your half of that is 15. So do you want to split it so that we can keep track, so that when you, if you're in the heat of the moment, Mr. Blem or somebody can nudge you and say, hey, you got 5 minutes left and that's what you wanted. How do you want to structure yours?
Here, I just want to make sure that I'm understanding correctly. It's 30 minutes for each motion,
Right.
both plaintiffs and defendants get 30 minutes, or it's 30 minutes in total?
It's 30 minutes in total. That takes an hour if you think that's adequate. If you think it's not adequate, you tell me. I've already, again,
So you're saying an hour in total for both motions then?
yes,
Okay, got it. So I would like to reserve, that means I have 15 minutes.
yes.
So I would like to reserve 5 minutes for rebuttal.
Mr. Blem, I'm going to kind of rely on you to keep track of that for his sake. Okay,
Your Honor, I just set a stopwatch and I'm going to set it right by him.
thank you.
Nice.
you. And for the defendants, the question I have for you is, do you want to designate, want to split it up equally on this motion?
Your Honor, the county
maybe not
and the
equally.
Secretary of State will plan to split it.
Then tell me what your split is when you start talking.
You got it.
And you all do the same thing that I just tasked Mr. Blem with. Mr. LaRue, maybe you can be the timekeeper on your side, and you make sure everybody stays within the guidelines, okay?
Sure.
All right. So, are we ready to go?
We're ready.
Okay.
Let's do it, Judge.
Please.
Woo! Let's go.
Good morning, Your Honor. We have brought this motion under Rule 60B 2, 3, and 6 for relief from the judgment based on an extensive analysis of a variety of documents produced by Maricopa, including the system log files for 446 tabulators, the other tabulator records. All of these documents were produced during a period between December of 2022, as we noted in our brief, through March. And they form the complete basis for the opinion. Not any one document gave rise to the basis of the opinion of Clay Parikh, who submitted a declaration in support of this motion, his expert opinion on a variety of issues. And I would note that in addition to the documents that were produced, we also rely heavily on some of the observations that came about in the report on the printer failures by former Chief Justice Ruth McGregor. That sets the backdrop, Your Honor, for the premise that this motion is timely. The information that we had was not available at the time of trial. And in addition, it is incredibly complex information that is not simply something that you can read and then put forward in a motion. It needs to be analyzed. As Mr. Parikh testified in his declaration, there were thousands of man-hours that went into the evaluation of these various documents that justified the basis for this relief. This information, there are 4 issues, Your Honor, that are new. First, the information rebuts the testimony of the Director of Elections, Scott Jarrett. It rebuts it in several key ways. If you recall at trial on what was called the fit to page or the fit to print issue, which is a 19-inch ballot image that was printed on 20-inch ballot paper, and that caused the tabulator to reject it because the timing marks were not aligned. And so that created an error code. Mr. Jarrett testified at trial on the second day. On the first day, he denied that that could ever even happen. On the second day, when he was brought by defendant's counsel, he testified that, oh yes, it had in fact occurred. And in fact, it had occurred 3 prior times, but he didn't mention that on the first day. And they said that the Maricopa was performing a root cause analysis on that, if you recall.
That's Scott
And that
Jarrett.
began early on. And that root cause analysis, which was ongoing, he testified, it was determined that some T-text not authorized by Maricopa made some setting changes to the printers. And that was the cause of this fit to print. The new evidence that is in our motion, Your Honor, shows that that was absolutely false. And in fact, just as Mr. Parikh had testified before, this could not be caused by a printer setting change on site. I want to note page 12, which we saw of Justice McGregor's report. There was a shocking revelation when Justice McGregor in her report at page 12 states that while they were performing testing of randomly selected printers, all of a sudden in the middle of the printing, these printers started printing one or a few fit to page ballots. And the key is, Your Honor,
Anomalies.
she also stated that none of the technical experts that they consulted with could explain how or why that occurred. Your Honor, as
Random
Mr.
errors.
Parikh testified, that's malware, or it is somebody remotely accessing the printer, which these printers are capable of remote access. And it happened as recounted in Mr. Parikh's report, not just with the Oki printers, but with the Lexmark printers, which further shows that there was malware or some other nefarious activity of remote access involved in that entire issue. The other thing is Mr. Jarrett's testimony that this only arose in 3 vote centers is false. For randomly selected printers, there was at least 4. Going to move quick. So that's a significant issue. Bombshell last night, or 2 nights ago. We had alleged in our opening brief that the defendants secretly tested all 446 tabulators after the October 11th certification for logic and accuracy. Those tests in the system log files and other documents received later confirm that 260 of those tabulators failed. 58% of the tabulators. I would note in our complaint
58.
that based on the testimony of over 200 witnesses who were voters at the vote centers, we pled, and this is in our reply, that equated to 59% of Maricopa County's vote centers experienced severe malfunctions with their tabulators.
Over half
It may be a coincidence, Your Honor,
on election day.
but it's certainly a very close one, if that. When you have 260 of 446 tabulators, which is 58%, failing a test, and then a similar percentage of vote centers failing a test before the election. In other words, they were going to malfunction. And then after the election, there's a debacle on election day, as we know. The Maricopa submitted a declaration in response to that motion by Mr. Jarrett. They now revealed for the first time that, after the October 11th certification for logic and accuracy, we realized that we didn't configure the vote center tabulators to not accept provisional ballots and not early ballots. So we went in, we rewrote the memory cards, overwrote the memory cards, installed what they said was previously approved logic election definition software. They totally reconfigured these machines. Under 16449, it mandates that whenever something like that is done, the logic and accuracy test must be performed again. It states that both the automatic voting tabulating equipment and the software need to be tested. That voided all of these tabulators, all 446 were voided. You layer on top of the fact that over 260 of them, 58%, failed, and then you get to election day, then there was this debacle on election day at 59% of the vote centers. Your Honor, the 2 situations before the election failure on election day, the number, the violations of the statute, that's clear misconduct and intent. This evidence would support our allegation that this election was rigged. It is. And this evidence.
It's good evidence.
A relief from the judgment. And there's much more detail in the paper, Your Honor, but I just want to add one more thing before the situation that Justice McGregor, where the printers started randomly printing one or a few fit to print printers and nobody could explain why, that's damning, Your Honor. As Mr. Parikh testified, only 2 things, malware or remote access. With that, I'll reserve my time.
Thank you.
All right, this was Clay Parikh.
Okay.
You remember him. This is when we covered him last time. This is actually a screenshot from something we did when he was testifying. He submitted a new declaration supporting all of what he just said. And after this stream is over, I'll forward us all over to the Kari Lake video that we recorded yesterday morning that just got
Hold
edited.
on just a second.
And it goes through this
No, it writes
entire
so
motion
fast.
in detail. But he is supporting it again. He got a bunch of file logs
All right.
and,
your
and
time.
much more material.
Thank you, Your
Morgan,
Honor.
how do you want to split it?
I don't anticipate needing more than 5 minutes. The rest Mr. LaRue can have,
5 minutes, 10 minutes.
Mr. Honor.
Okay, so Mr. LaRue, if you could help with the timing, I'd appreciate it. Mr.
A
Morgan,
bunch of
go ahead.
technical objections, I imagine, are
And for the
coming.
record, Craig Morgan for the Secretary of State. First, I would be remiss if I didn't thank the court and its staff for all their hard work the last few days. I know this hasn't been easy, and I want to extend my thanks. Judge, you said at the beginning, you've read our papers. Are there any specific questions the court has that I can address directly to help you reach the right decision today?
Believe me, I've gone through and asked myself lots of questions and gone through it. I just going to let you decide what's the most important. I don't have anything that's a burning question for either side on this motion.
Well, thank you, Judge. Then I'm not going to recast my papers. I think our papers were thorough, and I think they explained to the court the reality here is that Rule 60 relief is just simply inappropriate. I will tell the court that notwithstanding everything Mrs. Lake's lawyers just said, we have no reason to believe any of that's true. And even if it is, it just doesn't matter. It doesn't matter because they're not entitled to Rule 60 relief. This is an election contest. This is not a slaction. The procedural rules cannot trump the legislature's dictate that these actions happen quickly and they happen with finality.
Finality.
And here we are, Your Honor, all
Sorry,
these
it's too
months
late.
later,
Sorry.
and they're seeking Rule 60 relief, and they haven't even met the legal standard for Rule 60 relief as stated in our papers, notwithstanding the fact that this is an election contest. You combine that with the reality that it is an election contest, it's simply inappropriate, Your Honor, to seek and obtain relief from judgment, especially given that the mandate's direction is so clear and precise. We are here on count 3 and nothing more. So I would encourage the court to let us focus on count 3 and deny the Rule 60 motion. I cede the rest of my time to Mr. LaRue, if there are no questions.
Yeah, but count 2 was
Okay.
dismissed on false pretext.
Thank you.
It was dismissed on evidence, according to Kari Lake's team, that Scott Jarrett got up on the
Mr. LaRue?
stand and
Thank you, Your Honor.
lied.
I too am cognizant of what Your Honor said, that you have read the papers. So I will attempt to only cover things that may need to be expanded upon. First, their motion for relief is jurisdictionally barred
Here you
for
go.
2 reasons that dovetail together. Most significantly, they want relief from this court's denial of count 2 of their complaint. Count 2 of their complaint, if the court looks at count 2 in the complaint, it is about whether the ballot on demand printers were subjected to the testing that is statutorily required by 16442, ARS 16442. Now, ARS 16449 is the statute about logic and accuracy testing. That does not appear in count 2, Your Honor. Nowhere do they mention ARS 16449, the logic and accuracy testing statute. 16442 is the statute requiring that before any election equipment, election voting systems rather, can be used in the state of Arizona for elections, they have to be certified by the Secretary of State. And the Secretary of State, pursuant to that statute, has a committee that examines any new equipment that's brought to Arizona for use in Arizona elections. That statute has nothing to do with logic and accuracy testing. It's a different statute. So now what plaintiffs want to do is say, oh, there were these problems with the logic and accuracy testing, which there weren't. We explain that in our response.
With your witness.
But they say there were these
Scott
problems.
Jarrett.
We need the court to consider count 2. What they're trying to do, Your Honor, is amend count 2. And they can't do that. Grounds v. Law and Kit v. Holbert, 2 cases cited in the briefing, and Kit v. Holbert, just in case it wasn't cited, is 30 Arizona 397. Grounds, I know, was cited several times in the briefing. Both those cases stand for the proposition that a contestant cannot amend her pleadings after the close of the filing period for election contests.
It's not
and what that means, Your Honor,
amendment.
is that even if this court had not denied count 2 back in the beginning, by the time we got to trial, it would have been too late for them to make this amendment that they want to make. It simply can't be done under the statute, and the statute is jurisdictional. Finally, Your Honor, I just want to say to the court, I really don't understand some of the things that are occurring in this proceeding. Lake raised some allegations about Maricopa County's processes in its motion for relief.
Yeah.
We responded to those allegations in our response, and we included a declaration from Scott Jarrett that clearly set out what happened. And in Lake's reply last night, what we said was either ignored or misrepresented. I don't know what to do with that, Your Honor, other than direct the court back to the truth of what happened. Unlike what Lake says in her reply last night, there was no shocking bombshell. There was no violation of the logic and accuracy test. If the court looks at Scott Jarrett's declaration at paragraph 7, Mr. Jarrett says from October 4th through October 10th, prior to the logic and accuracy test, the elections department conducted testing on its tabulators, all of its tabulators that would be used in the election, including the spares, to make sure that they would successfully run ballots. And the memory cards with the election program were loaded on those tabulators. During that testing, they discovered that there was a security feature that is not required by law, but is a standard election integrity practice for Maricopa County.
Standard
that
practice.
was not loaded on those memory cards. And that was a feature that prevents the tabulators from tabulating provisional ballots or early ballots. And the reason that protects election integrity is it prevents double voting. It's a very important feature, even though our law doesn't require it. Otherwise, a voter could vote in person and then could take her early ballot and put it through the tabulator too and vote twice. So this security feature prevents that, and it was not programmed into the election program loaded on the machines, and we discovered that. So what the county did, and Mr. Jarrett lays this out in his declaration, the county on October 10th reprogrammed the election program to add that security feature.
After the certification?
Then that program was loaded on the memory cards that were tested in the logic and accuracy testing, which is a sampling of the tabulators. And so the logic and accuracy testing occurred on October 11th. Contrary to Lake's claim, it did occur, and Republicans, the same party as Ms. Lake, signed the certificate saying that it occurred. The election program had been changed on the 10th and was put through logic and accuracy testing on the 11th and successfully passed, and Republican witnesses signed to that effect. Then on October 14th, 17th, and 18th, Mr. Jarrett explains in his declaration, that election program was loaded onto memory cards, the same election program that had just passed logic and accuracy, and was placed in each tabulator that was going to be used in the election. That's the shocking bombshell.
Yeah, so you
that Lake
certified
wants
it,
to grab hold of.
and then you
It's
changed
not shocking
it,
at all. Maricopa County did what
and
it
then you
always
loaded
does.
the
It
changes
tested
onto the
its
thing,
equipment.
and you referenced the
It made
previous
sure
certification.
that things were correct, and it put its equipment and the election program through logic and accuracy testing as the law requires. Finally, Your Honor, just very quickly, Mr. Jarrett also explained in his declaration that the tabulators did not fail in this testing that was conducted from October 4th through the 10th, nor did they fail in the loading of the memory cards on October 14th through the 17th. What happened was sometimes ballots misread, and they can misread because the person inserts them crooked. This happens all the time. It happens on election day, it happens during early voting, and it happens when machines are being tested. If there's lint on the machine after cleaning, if the ballot is inserted slightly askew,
Lint
the
on
machine doesn't
machines.
read the ballot. And the
Lint.
log says machine failed to read the ballot. That doesn't mean the machine failed. It means the machine did exactly what it's supposed to do. And most often when the ballot is inserted the next time, the machine reads it. There was no massive failure of machines. This was all explained in the declaration. And Your Honor, my practice of law is that when someone explains what happens and it's credible and it's in a sworn declaration, I don't double down on my allegations. I don't understand what's going on here. But here we are, Your Honor. And with that, if you have any questions, I'll be happy to address them.
A lot of technical
Thank you, Your
arguments there, and essentially saying,
Okay.
my understanding of his
Wait a
argument
second here. We're at,
is that the testing was
minutes.
done, all the certification was
So,
done, and that
that's it for defendants?
Unless,
Unless the governor's council wants to say anything, Your Honor, the secretary and I believe the county have nothing further unless the judge has questions.
Donna? No?
Nothing further for the governor, Your Honor. Thank you.
Then, Mr. Olson, you're back up.
So the
Yes, Your Honor. So correct a couple things. Mr. Jarrett testified at paragraph 17 regarding the 260 tabulators that showed error codes on the slog files of the same types of failures that arose on election day, the same codes. 260 tabulators failed between October 14th, 17th, and 18th, and the same percentage or roughly the same percentage failed with the same error code. Council wants to make it like those error codes were just the result of somebody, putting in a ballot incorrectly. Mr. Jarrett parses his words just as he did at trial. He says an error code of the same does not necessarily mean that it was a malfunction. He never says in his declaration that the malfunction didn't occur. He's parsing his words. Secondly, 16442 is not the sole basis of our claim. Our claim was that there was a massive failure of vote center tabulators at nearly 2/3 of Maricopa County's vote centers. That was caused by defendant's misconduct. That's our claim. It's not limited to just 16442. The shocking revelation, and it is shocking because they've now been called out, that they reinstalled software on voting center equipment without testing it. You just can't take software from one computer and put it on another and say it's okay. And
100% right.
16449 makes that very clear. And so defendants waited 7 months to reveal this, and they only did that. There's their testing that was done after certification. On November 19th, the AG sent a letter to Maricopa detailing and request for information regarding the debacle on election day. They never once mentioned this, just as they once mentioned their root cause analysis into the fit to print issue. All of these things are coming out simply through the production of records and our own analysis and Justice McGregor's report, which unequivocally, according to the testimony of Mr. Parikh, shows malware. There's only, and Your Honor yourself noted, I believe, in your December 24th, 2022 order, that if it was a setting, you would expect the same thing to occur across all ballots, which is true. If it was set, you wouldn't expect random printing of misconfigured ballots, which is what Justice McGregor observed. That's malware, Your Honor. This election is fatally flawed on this issue. Now, we've also put forward evidence that there were at least 8,000 ballots that were printed out with the same error codes associated with the fit to page issue. Those were not duplicated. That's in Mr. Parikh's declaration. So there was no question. These were not counted, as Your Honor. And the reason why that's significant, because those illegal ballots and any others would be accretive and would be relevant to any analysis Your Honor is going to undertake with respect to count 3 on signature verification. Because as the Supreme Court said, we are supposed to provide, and we have, a mathematical basis to show that the election should be overturned.
Good.
So those illegal ballots would be accretive to that issue. Your Honor, this claim should proceed to trial concurrently with count 3. Let the defendants depose or question Mr. Parikh. Let them put up their own experts and see if they can explain, which again, 260 tabulators, Mr. Jarrett does not deny that they malfunctioned in his declaration. And he gave false testimony at trial regarding this issue as we recounted. Thank you, Your Honor.
Yeah, and since all of those things add up to the cause that justified the dismissal of count 2, they're saying bring count 2 back. That's the basis of this motion. They want to proceed on a whole second issue as well. And so we heard a lot of technical arguments from the defense. They're really giving this judge anything to latch onto: jurisdictional stuff, technicalities about procedural
Second
processes
motion.
and modalities.
This is the defendant's motion. This is the renewed motion to dismiss by each of the 3 named defendants. As I've indicated before, I read everything that you submitted on this matter as well. So on this motion, the defendants will go first and have the opportunity to reserve some time to go last on rebuttal if they wish, and splitting up their time.
Your Honor, thank you. For the defendants, at least for the Secretary of State, all I would ask the court to do is just take a look at the reply we filed yesterday for purposes of our argument. I will cede whatever time I might have to Mr. LaRue and the Governor's Council. Thank you.
Okay. Ms. Khanna, I mean, how do you want to proceed?
Your Honor, I'll just have a brief 5 minutes and then I'll give the rest of the time to Mr. LaRue on the motion to dismiss, and then whatever left over we'll save for rebuttal.
Okay, what's we? Because what I'm after is that Mr. Morgan has basically said he doesn't have anything more than he put in writing, so he's not going to take any of the 15 minutes. Mr. LaRue, between you and Ms. Khanna, I need to know what you're carving out for rebuttal so we can have Mr. Morgan be your timekeeper. So between the two of you, how do you want to split that and how much time?
Thank you, Your Honor. The Governor's Council can handle rebuttal, and we will reserve 5 minutes.
Okay. If I've understood correctly, you're going to take 10 minutes right now, and Ms. Khanna will take 5 minutes on rebuttal, and that's your 15 for the defendants.
Say that again. I'm sorry.
You said, I thought you said you were going to take 10 minutes of the 15 minutes, then reserve 5 minutes.
Your Honor, I'm sorry.
Set me straight, please.
No, I was thinking we were dealing with 30 minutes. My apologies, Your Honor. It's been a short night. No, I will take 7 minutes. We'll reserve 3 minutes for rebuttal, and the Governor's Council can handle that.
So I think where we are is I'll go for.
Oh, it doesn't matter.
Yeah, I think that leaves us at about, I'll go for 5 minutes. Mr. LaRue will go for about 7 minutes, and then we'll reserve 3 minutes for rebuttal.
Yes.
Now that adds up.
That's what I was trying to say. My apologies, Your Honor.
Very well. Okay.
This is their motion. They're arguing.
Mr. Morgan,
Thank you, Your Honor.
Be the timekeeper if you would.
Your Honor, it'd be my pleasure.
Very well. Ms. Khanna, you're going first. And then for petitioners, I think, Mr. Olson, you said you're arguing this as well.
Yes, Your Honor.
You get the straight 15 minutes in the middle.
Okay.
Mr. LaRue. Oh, you got Ms. Khanna. I'm sorry. Ms. Khanna, go ahead.
Thank you, Your Honor. The Arizona Supreme Court remanded this case for consideration of one narrow question, which is whether Kari Lake's count 3 regarding the signature verification claim in Maricopa County fails to state a claim for reasons other than latches. As we mentioned in our briefs, the answer to that question is absolutely yes, it does fail. Over the past several months, the parties have provided the court with a lot of words, a lot of paper, a lot of case law, a lot of argument. But when we turn down the volume on all the noise and just look at the actual words of the complaint, we find that there's just not much there at all. Count 3 alleges misconduct for mail-in ballots with invalid signatures. That's in bold under count 3 on page 59 of her complaint. Misconduct for mail-in ballots with invalid signatures. Count 3 itself consists of 7 paragraphs, about a page and a half. And the factual allegations for count 3 are contained in paragraphs 44 to 60 of her complaint. When we review those allegations, we should find the factual bases for her claim that Maricopa County committed misconduct by violating Arizona's signature matching law. But in fact, those allegations show no such thing. Count 3 relies on 2 categories of factual allegations. One is the declarations of 3 part-time signature matching workers, and 2 is the analysis of 2020 election data. As we state in our briefs, neither of those categories hold up, and I'll just briefly address each of those. First, on the signature worker declarations. Those declarations do not take long to read, Your Honor. They're about 5 to 6 pages each. Many of the statements in them are identical. And even taking all of their allegations as true, as this court must on the motion to dismiss, they boil down to about 4 basic alleged facts. Number 1, level 1 signature reviewers, the experienced of all of them, rejected a significant number of mail-in ballot signatures, anywhere from 15% to 40%. Number two, upon further review of those rejected ballots at the manager level, and with access to an even greater number of signatures from the voter files, a significant number of those rejection determinations were overturned. Signatures were deemed valid. Number three, according to the declarants, there were not enough observers watching those level 2 and level 3 reviewers when they were verifying signatures. And number four, nor were there sufficient number of safeguards or observers during the cure process to ensure that those curing mismatches were following the proper procedure. Absent from these declarations, Your Honor, is any allegation that Maricopa County failed to comply with the signature matching statute, with the election procedure manual, or with the Maricopa County election plan. In fact, they only underscore that the county followed the procedures set forth in the code and in the manuals established well before Election Day, whereby first level reviewers flag potential mismatches for manager level review. Those managers make the final calls on each signature on each ballot with access to a full array of signatures available in each voter file. And while these declarants bemoan the lack of observers in the process, all they allege is that nothing prevented election workers from engaging in misconduct. But of course, this court cannot presume bad faith and abuse on the part of election officials just because there may have been the opportunity for bad faith and abuse. In fact, it presumes the opposite. It is not the case that unless Ms. Lake or her declarants saw each and every step of the process with their own eyes, that they can infer that the process either didn't happen lawfully or didn't happen at all. Ultimately, when you read the words of Ms. Lake's declarants, tell us nothing that would support a or didn't happen at all. Ultimately, when you read the words of Ms. Lake's declarants, tell us nothing that would support a claim in count 3. The first pillar of count 3 completely falls away. The second pillar is the analysis that Ms. Lake provides of the 2020 election. Now, that category really speaks for itself, Your Honor. Even when taking all those allegations as true, all it speaks to is the 2020 election. The 2020 election is no more relevant or informative of what happened in this election than is an election that took place in New Mexico or Florida. This contest about whether or not Maricopa officials engaged in misconduct in November of 2022. Data and allegations about an entirely different election provide no basis whatsoever to claim or assume deficiencies in this election. So that second pillar falls as well, and count 3 collapses entirely. The last quick point I'll make, Your Honor, is that even if either or both of these two categories could state a claim for relief, Ms. Lake does not come close to satisfying her burden of alleging a competent mathematical basis to conclude that the outcome of the election would have been different.
Mr. Morgan's telling me that you're at 5 minutes. Well, you got 5 minutes left, so this is what you wanted to reserve.
It's fine, Your Honor, if we waive our reserve time and she continues.
Sorry,
I'll just finish up in just a brief summation, Your Honor. I just wanted to make clear that Ms. Lake, I think, misunderstands the standard to think that by throwing out a host of numbers, that somehow provides a competent mathematical basis. But in the end, all that she offers, in the words of the Court of Appeals, are untethered assertions of uncertainty. They are untethered to actual ballots. They're untethered to this election, and they're wholly untethered to reality. We'd ask that the court dismiss count 3 in its entirety.
All right. So
thank you, Your Honor.
Kari Lake wants to bring back a count that the judge dismissed previously. They want to dismiss
Thank you, Your Honor. I'll be very brief.
That the judge didn't dismiss previously. We've got trial scheduled next week.
Counsel for Lake just discussed 8,000 ballots and then said this implicates count 3. And so I'm just going to say for the record, all the ballots were tabulated. There's with regard to the motion to dismiss, everything is laid out in our papers. I just want to briefly explain. There is a huge difference between the grounds case and the Rays case. Your Honors, I'm sure aware, in grounds, specific ballots were challenged, specific voters who during the inspection of the ballots, it was discovered that these voters were not lawfully eligible to cast a ballot. So they were identified with specificity. In Ray's, the Yuma County Recorder didn't do any signature verification at all. So every ballot was implicated. Now, in our motion to dismiss, we pointed out how it's really too late to bring the type of challenge that Lake wants to bring, not because of latches, but because of the statute itself. That this type of challenge just is not authorized under the election contest
Yeah, because the
statutes.
election's
And
over.
we cited a case for that proposition,
Yeah.
and we made some arguments
That's why we hurried so
from the
quickly.
law. And then in the response to the motion to dismiss, for the very first time, so far as I'm aware, Lake changed her theory. And she said, no, we're not challenging signature determinations. We're saying that signature verification didn't occur at all. That's the first time that's ever, to my knowledge at least, the first time that that's ever been raised.
Because they got the records after the trial
and so
was
it was
over.
brand new. But it might be because Lake is now trying to fit under the Ray's analysis, where you toss out all the ballots and you order a new election.
If 58% of the tabulators were problematic.
She admitted in her complaint at paragraph 52 that Maricopa County rejected 587 ballots for having signatures that were not consistent and had not been cured. So that admission means Maricopa County conducted signature verification. Then you have the three declarants who also, and this is laid out in our papers and in the secretary's papers, it might be in the governor's papers, but the declarants testified that they participated in signature verification. And they said verification was ongoing at levels beyond them. So this idea that signature verification didn't take place just isn't sustainable. Finally, Your Honor, I just want to say on behalf of Maricopa County and the Maricopa County Recorder, the assertion that this election was rigged is offensive and it's untrue.
Here we go.
And if Your Honor has any questions, I'll be happy to address them.
Fine.
Thank you, Your Honor.
Okay.
Yeah, he's offended. Yeah, very offended. Okay. No questions.
Okay.
So this is mirroring the same pattern as the first hearing, the first set of hearings that we saw, where the government is trying to make this extremely narrow, extremely
By my calculations, you used
technical.
about 9 minutes. Is that right?
Yes.
That's right, Your Honor.
Okay. All right.
Time's
Even
very
if it
important.
weren't, it would be.
Very well. Mr. Olson, you have your 15 minutes.
Thank you, Your Honor. First, we did not reframe our allegations. As a matter of fact, Your Honor may recall at oral argument on December 19th, I believe, 2022, when I argued, I presented to your court that there simply was not enough minutes in the day for defendants to review signatures. Our complaint is not simply based on just paragraph 151. A complaint is taken in total. The testimony of the three whistleblowers shows that level 1 reviewers were rejecting between 25 and 40% of ballots. There are 24 level 1 reviewers in any one sitting, but there are only 3 level 2 reviewers. That's an 8-to-1 ratio. There were 1.3 million mail-in ballots cast in 2022. At a 25 to 40% of that, that means the level 1 reviewers were rejecting anywhere between 325,000 and about 540,000.
Way over the margin of
As
difference.
I argued on December
Way
19th,
over.
and as is clear from the allegations in the complaint as total, we argued that there was simply not enough time, minutes in the day for the level 2 reviewers to do a review. And as a consequence, clearly mismatched signatures, which were not cured and were illegal, were entered into the system. This was corroborated by the testimony of Mr. Myers, who was in the curing function, where he would say that the rejections were between 20 to 30%, and he had been told for curing that there was going to be a flood of ballots coming his way, that they were processing about 60,000 ballots a day. He expected, from what he was being told, that the curers, the curing function, would get about 10,000 or 10 to 12,000 ballots to cure. He only got 10% of that. So the other 90%, which is about 10 to 12,000, because it's 12 to 15,000 he was expecting to see. The 10 to 12,000 ballots somehow magically were approved. As Mr. Myers testified, the math doesn't add up. And this is all part and parcel with the competent mathematical basis that's set forth in our brief, and I won't go through the nitty-gritty details. I want to say one thing, though. The evaluation, which was directed by the Senate President Karen Fann, that we the people did in reviewing the 2020 ballot envelopes with Maricopa, or the state's own record signatures, revealed, as pled in our complaint, that 20% of those signatures did not match. And about, I believe, 9.9% were what they were termed egregious mismatches. This isn't about relitigating 2020.
It's about a
What
pattern.
that information does, Your Honor, is it corroborates
Yep, it's a pattern. It's
what the whistleblowers testified to in their declarations that happened in 2022. This case is precisely like Ray's, except it's on steroids. Ray's involved a few dozen ballots. Here, there is competent evidence that on a motion to dismiss, the court under Griffin v. Buzzard has to accept as true, draw all reasonable inferences, and if plaintiff cannot plead any claim for relief, that's the only time to dismiss a case. We're not here to prove our case. The witness's testimony, all of which is consistent, all three of the declarants, the Shelby Bush declaration with the We the People analysis of the 2020 data, it's consistent. So even if it's hearsay as the defendant's claim, that would still fall under an exception, a catch-all exception for the veracity of the evidence that would be presentable on a motion to dismiss. If they want to argue at trial, they can do so. The other point I want to raise when we talk about the time issue, because this is also pled in our complaint, we attached the report of former Attorney General Bonovich given to Karen Fann on April 6, 2022. That was his analysis after he said a very detailed and months-long investigation into 2020. Why that's relevant is not, again, to relitigate 2020, is because it corroborates plaintiff's allegations for what happened in 2022. There is, as we noted in our brief, Attorney General Bonovich noted that among other failures in the signature verification process that Maricopa had, they processed 209,000 ballots at a rate of 4.6 seconds every ballot, which is impossible. All of the evidence is consistent. We set forth a competent mathematical basis in our brief under either a proportionality standard under Grounds v. Laws, or simply because the votes are illegal that far exceed the margin.
good points being made here. He said that Maricopa County was on notice of this. 2020 was about that. There was signature problems there. There was a report that was conducted. They did a certification, so-called, of the
I
equipment.
do want to make clear, Your Honor, because I think everything is in our papers. I think we've addressed it. We've more than met the standard to defeat a motion to dismiss in our papers. The one thing I want to make clear is we did not reframe our allegation, as defendants here claim. That allegation has always been, just as I argued on December 19th, that there was not enough time in the day for the level 2 reviewers, which are 8 times fewer than the 2024, to even review the number of ballots that level 1 was rejecting. That is not a reframe claim. That claim is solid, Your Honor. And with that, I will stand down.
Good arguments there. So Maricopa County was on notice. They should have corrected.
Hold on. You don't have standing. Okay? You don't get to insist on anything. You're not appearing in the case. Pardon me? I don't, wait, you're not a, you haven't appeared as a matter of
Somebody's
record.
standing up back here and speaking up.
I believe, I think, just based on what you said earlier, you're the ones, the persons who filed the amicus brief. Even if you filed an amicus brief, it does not give you the right to intervene in the case and speak and be heard. Amicus means would file the brief and it would be considered. I haven't ruled on that motion, so I would expect as an attorney, you know that what you're doing is improper. Okay, thank you, sir. All right. All right, we're back to the rebuttal that you have for the defendants on this motion to dismiss.
Your Honor, on behalf of Governor Hobbs, we'll rest on our papers. I think we've addressed everything that the court needs to know on this motion.
Very well, then Mr. LaRue, do you have anything that you were going to add?
Just very briefly, Your Honor, 3 quick points. First, with regard to the declarant testimony that counsel for Lake mentioned, I think it's important to remember that the declarants and their declarations said things like, I think I rejected this many, or my memory is, and I don't have the declarations in front of me. I don't remember the exact words. Your Honor can see that though. In other words, it's not clear how many signatures these declarants rejected. They're going off their memory, and I'm not questioning whether they're trying to state the truth. It's just they themselves acknowledge, you know, it had been a while since they had done this, and they weren't keeping notes of how many signatures they rejected, and they think they rejected so many. That doesn't mean that they did. Second thing that I want to say just very quickly is that as explained in the papers, there are multiple levels to signature review, and the voter gets an opportunity to cure signatures, which means that even if at the initial level, an initial one reviewer rejects signatures, that doesn't mean that those signatures are actually not going to be found to be consistent or that they're going to be cured. The level 1 reviewer has no way to know what the final outcome will be. And I believe the declarants actually say that in their declarations. I think they've been attempted to be honest in these declarations. They don't know. Counsel for Lake said that the analysis from 2020 showed that signatures did not match in 2020. And that's the type of challenge that they're bringing here. That again, Your Honor, means they're shifting back to, they're making challenges to signature determinations. And as we said in our papers, that's a very subjective process. 2 people might look at a signature and one might say, I think that's consistent, and another might say, no, that's inconsistent. And there's no line rule in the law that says when a signature is or is not consistent. This is something of an art in election verification work.
Especially
it's not really a hard and
really
fast
depends on
science.
who they voted for too.
And that's why the
Katie
level
Hobbs,
2 reviewers and the level 3 reviewers have more
Kari
experience
Lake,
and are able to look at these. They have
get rid of
additional
it.
training. They have
No,
access
that
to
doesn't
more
match at all.
signatures than the level 1 reviewers, and they can look at these and make their own determinations. If we would bring signatures in here, Your Honor, you might think some are consistent and I might think they were inconsistent or vice versa. But the law entrusts this to the recorder unless something happens like happened in the Ray's case, which did not happen here. Finally, Your Honor, with regard to the speed of processing ballots, I know that cyber ninjas and their investigation, and maybe we the people in their review of cyber ninjas investigation and the data provided by the Senate, they came up with numbers regarding how much time it was available to look at each signature, and counsel for Lake is relying upon that. The reality is the county rebutted all that in documents that it produced following those reviews. I think they were called Setting the Record Straight. They're on the county's website. I didn't realize that would be an issue today, but they are public records. The court can look at those if the court is so inclined. The reality is the 4 seconds per signature, or whatever the statistic was that was thrown out in those supposed examinations was just wrong. It's not the correct amount of time. And with that, Your Honor, unless you have any questions, I will stop. Thank you, Your Honor.
Questions? All right.
And with that, Your Honor, unless you have any questions, I will stop. Thank you, Your Honor.
Questions? All right. Okay. And are you Mr. Heath? Okay.
Yeah, that's
Mr. Heath, I apologize. I'm focused on taking notes and trying to get to that. I wasn't trying to be rude to you, but
He
I
wrote,
take you, I haven't ruled on your motion, but even if I granted the motion, you understand it's amicus, it's just limited to the brief and you don't get to intervene and participate.
Just note, there was no request as well in this other amici brief here.
I can't hear you.
There was no objection here or a request in the other amici briefs that were accepted by this court already. So I'm not sure if that's actually an issue we had, but it's all no. Thank you.
Well, I was just explaining to you why. I was just trying to hopefully make it so that you aren't personally offended. I wasn't inviting an argument that to which I don't think you have standing to make, and I don't have your appearance on the record. And so thank you. So don't worry about offending me.
don't worry about offending me.
It's trying to do the right thing in the right way and trying to make sure that we've got everything covered appropriately here in
Good, they
terms of
settled it.
procedure and
Good,
practice.
good. Settled it down.
All right, so I have everything. I will now take this under advisement and issue my ruling. So, good idea.
I'll forget it, sure, Your Honor.
I don't believe there's anything else that I had that needed to be done today. So I can excuse you all, and I will do my best to get this done as quickly as
I do
possible.
have a question, if it's okay with the court, since we're all here. Your Honors, as you recall, and I want to proceed how the court wants me to, and I want to make sure that I do it right and expeditiously. But since we're all here, the court did order that we would disclose experts yesterday on May 11th, and the disclosure has to include the expert's substantive opinions and the basis for those opinions. And I know it's filed with the court. The question I have for the court is, obviously, from our perspective, it doesn't meet that standard. Do we need to file a motion, or is that something you'll take up on next week? Because given the compressed time frame, I just want to make sure I'm preparing and I know what I'm preparing for. Because as it stands, Your Honor, I don't know how to prepare to examine witnesses who haven't given any of the information the court ordered them to provide.
At this juncture, I'm just going to leave the record the way it is, okay? And we'll have to deal with things as they come. Thanks, Charles.
Your Honor, I do believe that this met the court's order. As I recall from the hearing, you said if the experts submitted a report, then they couldn't testify. So there is no report to submit because we are bringing these experts and we disclosed the topics they were going to testify, the precise topic that they were going to testify about.
Well, let me just enlighten you on Rule 26.1. He's correct that if that was your expert disclosure, you wouldn't have any expert testimony at trial, period. Because what I clearly wanted and clearly tried to set out, yeah, it's true that if you have a report, you don't get to testify and put the report in at the same time. But you have to disclose not only the subject matter, but like I said at the last hearing, the substance of the opinions and the bases for each opinion. And then I went into detail and said, if somebody wants to advance an opinion that appears to be a minor offshoot, that, that is a reasonable inference, my inclination might be, depending on what it is, to not have a problem with it. But if a new opinion, never disclosed, is offered, then it wouldn't be, used, or I wouldn't admit it. This came about because of complaints from both sides that neither of you knew what to anticipate from the other's witnesses. And an election contest is unique. You haven't gone through initial disclosure statements. You haven't gone through discovery. You don't have a Rule 26.1 supplementation that you've had to do. You don't have all of these civil procedure steps in place because it's an election challenge. And therefore, you both agreed that you would disclose the subject matter, substance, basis for the opinions. And so that's what the intent was to disclose that. As I have it today, neither of you have done that. The defense said,
That's right.
We don't have any experts we anticipate, but to the extent that we would call, I think it was Mr. Martinez.
It was Mr.
I don't know who it was, but anyway, that would be basically a fact witness.
Correct. And your order, by the way, Judge, your minute entry said, and I've got it right here.
Okay, well, you don't have.
What it's, you've essentially captured your minute entry, is our point.
Your Honor, apologize if there was a misunderstanding. What I would
It's a big one.
request, Your Honor, just given the compressed time schedule, we will file
Well,
by the end of today.
Here's my problem. Some of this goes into, I'm dealing with rulings at the same time you're supplementing and doing things, okay? And that's why I said I wanted it today, or actually yesterday, okay? So it's not a moving target. You know, these are all things. The only thing that your disclosure said was, depending on what the defense witnesses say, these experts are going to address certain issues, as I recall it. I've got it, but
I have copies too, Your Honor, for you.
bottom line is if that were a 26.1 disclosure statement at any other trial, you would have no expert testimony, period.
We're waiting for the ruling. The judge is
And
making it painful.
I'd assume that as far as practice in Maricopa County and under the Arizona Rules of Civil Procedure, that's something that stood.
Are you going to let him in?
So I'm not here. The problem with it is this. The rules of civil procedure do apply, but they can't all apply to an election procedure because it's impossible to comply with the time constraints.
It's too
I had
tight.
to, once the election is certified, you have 5 days to make a challenge. You don't get to amend what you're challenging. That's the challenge. And then the complaint's supposed to set forth what it is specifically you're challenging. And then you all said, we understand that's a problem for both sides because we don't like being in trial. And the first thing we hear is what comes out of a witness's mouth is the only disclosure we get. So with an agreement that you both wanted disclosure, that's why I put that order in place. But it was clear what it was meant to do. So supplementing, I have no idea what these experts are going to say based on what you supplemented. There was no
They won't say anything different than the matters upon which we offered them to testify, which, for example, was signature.
Subject matter.
Correct.
But that's not, even with a lay witness, you have to disclose not just the subject matter, but the substance of testimony under the rules. But with an expert, it's even higher because an expert, what you have to disclose is what the expert's opinion is, how they arrived at that opinion, and what they relied upon to reach that opinion. And that's what I was looking for, and that was in the minute entry. So you can sometimes agree among the parties to have a report substitute for that, but there are reports. Well, there are some reports, but on this particular issue that is set for trial. So the problem is it's not going to send me back to rule on these motions. And you're going to say, I'll give you stuff later.
We'll get it to
What
you
am
by
I
5
supposed?
o'clock, Judge. We'll get it to you by 5 o'clock.
You're putting me in an impossible spot. So that's why the order was there, was to disclose it.
We'll get it to you by the close of
So
business
that
today.
not just them, but I would have it today as well.
Sorry for the miscommunications. You'll have it by the end of the day.
And Your Honor, if I may,
Yes.
I was actually specifically under the impression that the disclosure was not meant for your review in considering today's motions. I apologize if that was a mistake, but they specifically raised the issue of disclosure, to which I specifically responded, Your Honor, we don't get disclosure. We're not getting any disclosure. And we haven't gotten any disclosure from the other party because it's been their position the entire time that the Arizona Rules of Civil Procedure do not apply in an election matter. And that would apply to Arizona Rule of Civil Procedure 26.1 with respect to expert disclosures. I specifically removed that citation to the rules for the civil procedures and cited to your rule in our disclosure statement. We thought the intent was to let them know the general areas they were going to testify about and not give a report, because this court had made it clear that if we submit reports, our experts cannot testify. And we need our experts to testify in person rather than simply basing their testimony on a report.
The report, what I stated was the report would not be admitted in addition to the expert's testimony.
Our confusion.
So if you offered an
we'll
evidence,
supplement our filings
then
by
it's
the end
not
of
going to be
business.
admitted. What it does do is discloses to the other side what's anticipated. And you're correct that the agreement that you had, let me jump back and say, there was an argument at one point in this case that the rules of civil procedure don't apply. And I overruled that. We wouldn't have a Rule 12b6 motion. We wouldn't have, I mean, all your motions are made pursuant to the rules of civil procedure. And so the problem is they don't, every facet of the rules cannot apply because it's just not physically possible with the time constraints that there are with an election challenge. The Cullen case makes it clear as well that the court is not at liberty to rewrite the rules of civil procedure as they apply. I can only apply what I believe from the rules does apply. I can't rewrite the rules. And so, having said that.
Here it comes.
Understood, Your Honor, but we would simply ask for leave to amend our disclosure so that we can produce reports to the other side. But we would ask them at no time should they seek to have them admitted into evidence between now and trial.
Well, they wouldn't. Okay.
Yeah.
Whether they did or you did, it would be cumulative. They may use them for impeachment in terms of this is what your report said and that type of thing. But
Expert witness ruling. Do they get experts or not? Come on, Judge. Give them by the end of the day. It's Friday. Trial's next week. Give them till Monday.
do you have reports
Yes.
from the experts
We'll get them,
that relate
Judge.
specifically to the testimony that they'd be offering
We'll
in this
have 'em by
case,
5
not
o'clock.
reports from other cases?
You better get
No,
them.
Your Honor, we do not currently have
Ah.
a report.
Get it.
Okay.
And we specifically did not ask them to prepare reports, Your Honor, because we had no intention of submitting them to this court for the various reasons stated, that then they would not be able to testify.
But you would have had to, well,
You're on the phone text messaging your expert. I need a
If
report
it
in 6
please
hours,
this
bro.
court, rather than report, we can expand on our disclosure by 5 p.m. today.
There we go.
To include the substance of what they intend to testify about and the basis of those
do
opinions.
that, or you can withdraw your agreement to do the supplementation, but the only thing that I have of record is what's in the complaint.
Thank you, Your Honor. I don't think it's fair that they can supplement by 5. If I can just expand on that, Judge. A deal's a deal.
Well,
We went through this. If your orders don't mean anything, then why have them? I mean, we went through this. I have been working nonstop. You have been working nonstop. These people here with me have been working nonstop. And part of that is because we are following the court's orders and the rules.
Pound
It
the
seems
table.
like they just don't want to have to do it.
He's going to be pounding
That's
the
not
table
fair,
now.
Judge. That is not fair at all.
5 o'clock, relax. He'll get it. You'll get it this evening.
There should be no expert testimony if we have a trial in this case.
There we go. Yep.
All right.
You got to get the expert report like now. Like Clay Parikh needs to be just typing away right now.
I think the part that Mr. Blem said about he didn't understand that that would play any role with regard to the motions to dismiss. That I can excuse by just basically saying you could supplement by 5 p.m., but I'm not considering anything with regard to the supplementation because defendants have no expert witness supplementation and plaintiffs don't have any at this time, but I don't need to take that into account for ruling on the motions. This is a fast-moving process, and I understand, yes, there's probably been a lot of very short nights for everybody, even in different time frames. Time zones, I meant. So I'm mindful of that, but I'm also trying to be, this is agreement about disclosing things so that you're prepared. And so this is agreement about disclosing things so that you're prepared. And so
I'm sorry, Your Honor, this is our agreement?
yes, the lawyers.
Okay, I apologize, but I have no intention to argue with you, Your Honor, but I don't necessarily believe it's by agreement that we agreed to give expert reports.
No, it was supplementation.
Well,
You were the one that
I would agree to supplement, Your Honor.
I'm sorry to speak over you. You're the one that said you were prejudiced trial. I mean, Mr. Morgan brought it up and said, hey, we don't want to be surprised at trial by hearing for the first time out of an expert's mouth, this is my opinion. And you pointed out that you were in the same disadvantaged spot before because witnesses would take the stand. We had no idea. And my order actually went to the lay witness too, so that you'd have the subject matter and substance of those disclosed. But in any event, okay.
Experts. Judge.
You have his order. Yeah, it doesn't say.
Okay, it's fine. I'll give you till 5 o'clock today to supplement. Do you understand what I'm asking for by supplementation?
Yes, Your Honor.
You sure?
Not just the opinions, the subject matter, the opinions themselves, the basis for the opinions. In other words, I relied on this, and this to draw this conclusion. And so opinion, subject matter, the opinion themselves, basis for the opinion being disclosed.
Good.
Okay.
Oof.
Thank you, Your Honor.
Now, here's the other part that's problematic. In litigation, what happens usually, the plaintiff goes first and discloses all of their witnesses, including experts. Then the defense decides whether to retain an expert, and then the defense decides whether to have that witness testify, and then they do disclosure. So this is all being done differently. This is all disclosure at the same time. So as we stand here today, by 5 o'clock, you may disclose a mountain of material, and the defendants have absolutely no idea what it amounts to until they get it. And I've already asked them to do the same thing, which is to disclose. So if you're going to do it by 5 o'clock, then I'll have them do any rebuttal by 5 o'clock on Monday.
Understood, Your Honor.
For the record, Your Honor, just for the record, solely in case, no offense, please. We would object to any supplementation, but we understand the court's ruling and we will abide. And the other thing I'll note for the court is your ruling also was very clear. It only applied to experts. If you're saying it, please let me know, Judge, and we'll be sure to comply with that. But it says here it's experts. I just want to make sure it's right.
No, I was trying to fashion something that was going to accommodate the needs of both sides that expressed to me that neither one of you wanted to be surprised at trial. I was the one that also suggested that lay witnesses be included. If it wasn't in the minute entry, and then that's fine. We'll leave it with just the experts.
Very good.
Make it simpler. Okay.
Thank you, Your Honor.
Whew,
5
okay.
o'clock today,
Close call.
5 o'clock on Monday for the
Close call.
defendants.
And Your Honor, just so that the record is clear, we understand the court has made its ruling, but Maricopa County joins the Secretary's objection.
That's fine.
They want to keep
And
the
same with
experts
Governor
out.
Hobbs. Thank you so much.
Thank you all. Okay,
Whew.
I think that covers everything.
Close
unless there's
call.
something else you want to raise.
Raise your blood pressure on a Friday.
Nothing
Kari
from
Lake-
Practitioners further before I excuse you and let you go.
Yeah, they're gonna go they're gonna go race to their
Nothing more.
laptops right
Thank you.
now.
Anything from,
Other than, again, we want to thank the court and its staff for its patience and hard work. Thank you.
that's fine. Thank you. I will make a comment on this. I don't think it's inappropriate to do so, but I appreciate the hard work and effort that I've seen that's gone into the briefing, the research, the writing that I've received, because there are a number of issues that are novel issues. There are a number of issues that are complex in terms of their application. And I appreciate the legal research, the writing, and the thoroughness of the presentation. I don't think it's inappropriate for me to make a blanket comment like that to both sides to that extent. But we've done complimenting each other, and we'll get back to business, and I will do my part, and then we will proceed from there. Thank you all.
Thank you, Your Honor.
Thank you, Judge.
All rise.
All right. Woof. All rise. The judge leaving? We're just standing around, Judge. All right, please be seated. All right, so my friends, looks like that is the end of the proceeding. And we had some serious developments in there. We saw 2 different motions were being argued and held under advisement. So the judge will issue a ruling very soon. And I want to do a quick recap on what both of those motions were. And as soon as we can get our screen cleared up over on, yes. Okay. So we had 2 motions in the Kari Lake case that we just heard them argue about. Pretty important motions. The first one was Kari Lake's motion, which was a relief from judgment. And I'll go through this one again very briefly because we have a full video on this coming out soon that we dissected this whole thing in detail. But the other motion was coming from the defense, which was the motion to dismiss count 3. And so I want to run through these very briefly so that we can get our bearings straight. The judge, of course, is going to rule on these. But if you missed this filing from Kari Lake, this is what they were arguing about today. I mean, this was the real meat and potatoes. This was the substantive filing. And Kari Lake was saying they came up with new evidence. They found that Maricopa County falsely certified. The argument was they certified the thing, then they changed the thing, and then they put it into production. And that's not how it's supposed to work. You're supposed to have the final changes before the certification. This would be like in a DUI case. If they certified the DUI machine and then they changed a bunch of stuff and then they told us that the results after the change were still valid, we would have a field day with that. No case like that would ever survive if they changed it after it was certified. That's nuts because it breaks the certification. Same thing is being alleged here. They certified it after, they tested it after they certified it, and the evidence shows that they knew it was problematic. And if you go through this motion, a lot of different points and authorities here. A lot of the testimony is going to come from Parikh, and we already heard from him. He's going to tell us that there were 19 inchers that were being programmed to print on 20-inch ballots, and the whole thing was very problematic. And if you scroll through this motion in detail, the one part I wanted to share with you was the conclusion of this, where we learn that, of course, the person who was in charge of certifying a lot of these things, the person in charge of the elections, is the Secretary of State, Katie Hobbs. And she's the person who was running in the very election in Arizona. So this filing, we'll pull the full video out on it. Let's turn our attention to this filing. This is what everybody else filed against Kari Lake. This is the motion to dismiss. And this came in from Governor Hobbs. She wants to dismiss count 3. Here she says that Kari Lake is dissatisfied with her loss. She fails to state a claim. They give us the legal standards. And this is what we heard her team arguing about. So we'll hit the highlights here. Lake fails to state a claim for relief. Says it's not an adequate violation of Arizona's signature matching policy. So again, we're arguing scope. And the government argues that she just is not making a claim. She fails to allege any failure to comply. Talking about the comparing of signatures, says Lake fails to allege that there was any actual misconduct. While Lake's declarants may have been dissatisfied with the signature verification process, none of them actually contends that any signature verification worker failed to comply with the statute. And so if you recall from the last time we covered this trial, the government wants very specific people. They want names. And we thought that this was part of the fatal flaws in the first case, was that they didn't point to anybody in particular. And the person we were saying that maybe they should point to was Scott Jarrett. Scott Jarrett, the Arizona elections official, who changed his story a little bit from day 1 to day 2, talking about didn't know anything about 19 inchers on day 1. Day 2 comes out, knew all about 19 inchers. And we needed somebody to pin this on in order to move forward. So the government is trying that same defense. Well, it's all possible, but you're not pointing to any specific claims. Instead, all of Lake's declarants provide as their suspicious, subjective suspicions, devoid of any factual allegations that would transform those suspicions into a colorable claim. And so remember, we just got done arguing about expert witnesses, and the government doesn't have any expert witnesses, but Clay Parikh is the person who wrote this declaration. And so they're going to be presumably bringing him in to declare the following. Kari Lake's expert declares under penalty of perjury, the following is true. I've got personal knowledge. I have a master's in cybersecurity. I continually work in areas of information security and infrastructure. I've worked for several testing labs and tested voting machines, specifically Weil Laboratories, National Technical Systems. My duties were to perform security tests on vendor voting systems. Clay says, I have read the Maricopa County General Election Ballot Investigation Report. I've read the transcripts of the preceding hearings. I've also read multiple emails and received responsive documents. I've got several log files from Maricopa, and I've received responsive data that I have personally reviewed to create the reports. And so Kari Lake's expert says, I make the following observations. In response to a public records request, Maricopa County returned the system log for 445 voting tabulator centers used in the 2022 election. I got them on or about December 6. A thorough months-long analysis of the logs were conducted as part of our investigation. The meticulous data model design and intelligence isolation exercises included over 30 million lines of system logs. The scope of this effort encompassed several thousand man-hours in research, data, interviews, testing, and collaboration. Further complicating this time-consuming process were incomplete records that harmed our review. He says, to gain an accurate understanding of the 2020 election, multiple requests were filed. We got some of these, including issuing a subpoena to Senator Townsend. Specific information and data points sourced from the ballot-on-demand printers also came from a report of Chief Justice of the Supreme Court, former of Arizona, called Justice McGregor. Through these efforts, we have been able to definitively make the following determination. Kari Lake's expert, Clay Parikh, says, None of the 446 voting center tabulators used on election day were tested for logic and accuracy on October 11th in violation of Arizona law. Zero, not one. The only testing of 446 centers with the same election project occurred after they certified the machines on October 14th, 17th, and 18th. Subjected to a testing average, each one of 9 ballots, only 9 got fed through. 260 of the 446 voting centers failed the clandestine post-certification test with the same, quote, ballot misread and the same, quote, paper jam errors that plague voters on election day. Following the tests in October, with the failed state of the tabulators preserved, because they had failed during the tests that are in the logs, Maricopa County knowingly and intentionally, or with reckless disregard, distributed the tabulators to voting centers for use on election day. Knowing they were bad, put them into service anyways. The print to fit issue was not caused by the reasons that were given. They were not limited to the BOD printers, nor was the condition isolated to only 3 centers. Instead, the fit to print resized ballot images were found by the Maricopa Board of Directors to be produced intermittently. Voting center tabs logs revealed that over 8,000 ballots were rejected for print to fit conditions, and they could not be read. They required duplication. The speckled and faded print issue was also not caused by the reasons they gave. The combination of both printer errors yielded approximately 7,000 ballot rejections every 30 minutes the day of the election, a rate which persisted and was unmitigated from the times the polls opened until they were closed. 7,000 ballots every 30 minutes times a full day of voting is a lot of ballots that have problems. And most of the day of ballots would be going for Kari Lake, wouldn't they? Maricopa's testing, they say, did not comply with law. This is Kari Lake's expert, who presumably we're going to hear Kari Lake's lawyers disclose and hear from next week. Says the election procedures manual says specifically, the rules say, the Board of Supervisors or officer in charge of elections is responsible for performing the test on all voting equipment prior to each election. The conduct of the test must be overseen by at least 2 election staff or inspectors of different political parties and shall be open to observation by representatives from everywhere else. But systems logs and other records that were provided by Maricopa County from the government established that no vote center tabulators used on election day were tested for logic and accuracy on October 11th. They just weren't tested on that day. A failure to test all the equipment to be used is a failure to comply with the law. Maricopa County and the Arizona Secretary of State, Katie Hobbs, who conveniently was the Secretary of State, now happens to be the governor, both falsely certified that the testing was conducted in a public test on October 11th, 2022. But no vote center tabulators were tested yet. He refers us over to Exhibit 1. Let's see where this is. Look at this guy's report. Look at this report. Oh my gosh. This is Clay's report. This is the expert's report. He's sending us over to Exhibit 1. This is the certification. If we can ever get out of Exhibit 3. All logs from Clay. Here, Exhibit 1. Look at this. From Katie Hobbs's Department of State, Office of the Secretary of State. Isn't that interesting? Logic and Accuracy Equipment Certificate. Pursuant to the Arizona Revised Statutes, Arizona Secretary of State, Katie Hobbs, has completed the required logic and accuracy testing and certifies that the voting equipment, including accessible voting and tabulation equipment, met the requirements in Maricopa County for logic and accuracy testing standards on October 11th, 2022. Maricopa County will confirm that all early and provisional ballots from ICX accessible voting devices are duplicated prior to tabulation at central counting locations. Signed by the Secretary of State's office, her representatives. They also filled out this certificate of accuracy, alleging that in preparation for the November 8th election, this equipment was tested on October 11, 2022. We, the undersigned, do hereby certify that the pre-logic and accuracy test was conducted for November 8th in accordance with the law. We attest that the count produced by the equipment and programs was used correctly matched, and programs used correctly matched the predetermined manual tally of the votes provided. Bunch of people signing off on it. This person's, Kevin Gallagher, is a Republican. We got one Republican, another Republican. We've got two people from MCTEC, which is the Maricopa County Tabulation Center. We've got an office and another MCTEC, and we've got two Democrats. So we got Democrat, Democrat, Democrat. We got Democrat, 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 and two Republicans are there. Jani Bryant and Kevin Gallagher, the Republicans. We've got the other Democrats who are on this list. Here's an invoice. Central Count Election Day tab test deck. This invoice is from October 20th from Runbeck Election Services. And they're noting in the invoice the quantity of the ballots. And they're charging per ballot. This is interesting. So it looks like the rate per 1,000 is $290 per 1,000 ballots is the total. So we've got a couple dates. This was a test date. You see here this test deck, and here's another test deck. And those look like they're, Election Day tab test deck. Job number. So 27,000 ballots divided by 1,000 ballots equals 290 at a unit inventory equals about $8,000. What else do we have in exhibits? Total ballots inserted, 9, 5. Looks like these are the testing. 9, 5, 10 ballots here at Biltmore. Black Mountain had 5 ballots inserted. Total ballots, total misfeeds. Okay, yeah, that's what this number is. Look at all this. So apparently when they did the testing, we don't know exactly when that was. They say it was in the days after the 11th. But here you go. So they insert on this one 6 ballots, 1 is bad, 17% error rate. 7 ballots go in, 2 are rejected, 29% error rate. This one, 10 ballots go in, Biltmore, nice part of town here. 5 of those are rejected, 50% rejection rate. And they're just going through the list. This is from their own logs, it looks like. 16 ballots went in, 6 rejected in Cave Creek, 38% rejected. 14 went in a Christian community church. That's a good place to make sure you get your ballots rejected. 43% of those. Definitely make sure the Kari Lake votes at the Christian community churches are thrown in the dumpster. Good call on that one. Here's another one. 15, Community of Christ. Oh, that's great. 5 out of 15, 33% of those are gone too. Interesting. 58% on this one. Dayspring United Methodists. Oh, the Methodists. 58% of them. Get rid of their ballots too. Yeah. Yeah. Who else is here? What other religious people are here? Oh, yeah. Let's see. Okay, you see the list. There's a whole lot of them. Now, wow, 70% on this one. Gilbert Freestone Rec Center. Wonder what they're up to. 21 ballots out of 30 that were inserted all got rejected. Bummer. Looks like these are some pretty serious problems. 36% in Goodyear, 40% in a park school, 43% somewhere else, 50% in Levine. This is our election. 50% in the Love of Christ Lutherans. Oh, the Lutherans too. We almost forgot about the Lutherans. We got the Christians and the Methodist Christians, and the Lutherans are here too. We've got 50% of their ballots right in the dumpster when they were testing them. All right, so you can see all the various different locations throughout Arizona, and they're assembling all of them. Here's what they get in conclusion. Logic and accuracy test. Over 50% failed, 260. Looks like those failed. This reflects the date of the election, not the dates that the tapes were printed. A total of only 23 ballots were tested on the date of the election, not the date the tapes were printed. The printing was stopped and the tape is incomplete. It's cut short. Look at the details. He's looking at the paper. The paper is unsuitable. Media weight, printer settings. Here's another exhibit. Okay, so this is the full bench trial transcript. So that's the full proceedings that he's referencing. This is probably the... Okay, sorry for all the flashing on the screen as we fly around this document. But let's go back to his narrative and see what else he has to say now that we've looked at the exhibits. He says the only testing of the 445 voting center tabulators with the same project occurred on October 14th, 17th, and 18th, saying the Maricopa Board of Directors does not identify any evidence that pre-election testing was performed in accordance with the law, nor was any reference made to the process or the testing results. This is a pretty noticeable admission, I'll say, as the report repeatedly refers to stress testing under the law. Arizona law requires that both central tabulators and the center tabulators are tested. Jarrett testified during trial. When asked about testing, he said the following. For the county's logic and accuracy test, that is to run test ballots through. For the county's test, it's thousands of test ballots through our tabulator equipment. Both the central count tabulation equipment as well as the tabulation equipment that would be used at the vote centers. But the election manual states that the officer in charge of this election must utilize the actual election program for the election day, not a copy. One record that exists which documents all tabulator activity is called the tabulator log. A screenshot of this is below. This is what the tabulator log looks like. Looks like a command line interface. And it's just a text file. The system log for the tabulator begins on October 14th. Indicated there on line 7. You see him here. This is the system log, October 14th. What did the certificates say when they were tested and certified? October 11th. The same system shows that the polls were closed on election day, thereby confirming that this log is in fact the actual election day program and not a copy. It's important to note that the log encompasses all activity for the election project beginning on the 14th. The log does not indicate that the tabulator was operated prior to the 14th, including the possibility that it was tested on the 11th. There is no October 11th log there. It goes from January 1970 to October 14th when they first started using it. So why did they say it was certified on October 11th? The same also removes any possibility of any testing conducted on or prior to October 11th using the actual election program. All vote center tabulator logs have the first initialization date using the same election project as used in the other logs, 14th, 17th, 18th. This is at least 3 days after the county certified the tests. Every one of the 446 tabulators were subject to some type of test, everyone, either on October 14th, the 17th, or the 18th. That included an average of about 9 ballots, which 260 of the 446 tabulators experienced errors on that day. So 0% errors, as we just looked through the logs, 184 of the 446, 260 had errors. And now some of those errors were in the 10%-ish, but others were 40%, 50%, especially for the Christians. The test described above was not open to the public. No public notice was issued for those tests, and no political party observers were present as required by the law. And as we saw, they all signed the document for the other date, not on those other dates. There is no record of memory card seals for any of the voting tabulator centers on any of the checklists, also in violation of the law. It says the vote center tabulator logs show no subsequent attempts to rescan or to troubleshoot or to remedy the failures of the tests. No, because they were working perfectly. The malfunction was part of the deployment. That's great. They go, oh, this one's 70% error rate. Perfect. Yeah, this was perfect. Put it in. Where should this one go? Oh, yeah, put that in the Christian Methodist schools. Give that over to them. Considering the overwhelming failure of the vote centers during the post-certification testing as defined above, along with the absence of any actions to identify or rectify the cause of the failure, there remains no logical explanation other than that which was experienced on election day: continued failure. Maricopa County failed to provide the results aggregated by the election management system. And despite Maricopa County saying that they fact-checked, claiming that the purpose was to confirm the accuracy of the results, they wrote on their page, they wrote, the purpose of the test is to confirm that the votes are attributed to the correct candidates and the ballot measures in the election management system, and that each candidate and ballot measure receives the accurate number of votes. Predetermined results are compared against the results of the test. The equipment cannot be used in the election unless the results of the test are accurate. So they're saying our own tests say we can't use inaccurate equipment, but they know, they're on notice that they've got a ton of inaccurate equipment. The tabulators could not overcome the printer failures. This is what's leading to materiality. This leads to the actual change in the outcome of the election. They couldn't correct it after the errors were had on site. The first issue to point out from the footnote is that the central tabulators read all the ballots, but he says that's not actually true. The central tabulators do, and they did, reject defective ballots. I'll prove that later. But first, it is important to understand how the contest selections on a paper ballot are counted. Tabulators do not count or, quote, read directly from the document. They produce an electronic image of the ballot. Dominion voting system on both things connects with different software and creates an image in either black and white or grayscale at a certain dot per inch, depending on the jurisdiction's preferences. Only after this process is the ballot image passed to the software to analyze, authenticate, and then contest the selections. The software-controlled process, which digitally compares that electronic ballot to a predetermined map of the vote, so it's like an overlay, right? They put an image in, they say, we should have Katie Hobbs here. You should expect Kari Lake here. If you see a bubble here, that means Katie Hobbs. If you see a bubble here, that means Kari Lake. It's just a map that they just put over the top of it. The fit to print issue was not isolated to certain printers. The model makes up about 78% of the printer inventory, and it's widely used. He says there were major problems with testing. The samples were inadequate, and they also showed unmitigated problems. He says that Maricopa County officials referred to these as being able to scan defective ballots, but they were not able to scan defective ballots. How do I know? Here's the error counts that we saw. Back page grid error, 204 of those. Ballot ID not in the database, 84 of those. We had a back page grid error, over 1,000 of those. 838 of a front page grid error. Add them all up, the number is 3,000 problems. So when you discover errors during testing, it states that all failures must be reported to the Secretary of State, who in this election happened to be Katie Hobbs, who says, what are those errors about? Thanks for the notice. The tests that were conducted on October 14th and 17th and 18th have massive failures. Even though the test included only an average of 9 ballot, over half the voting centers failed the misfeed. You can see the chart again. One poll tape is printed before the polls open. Each tabulator is required to be tested, and many were missing. The tapes were missing. He says that the fit to print issue was an intentional malicious act. Ooh. During the Lake and Hobbs evidentiary hearing testimony, when questioned about the issues on Election Day, Scott Jarrett testified. He said, quote, well, a few of the other items that we've identified, though, as far as our on-ballot printer-on-demand printers, we did identify 3 locations that had a fit-to-paper setting that was a problem on Election Day. So those were at Journey Church in Glendale. They had about 200 or a little over 200 ballots out of about 1,500. That would be the same with Gateway Fellowship, East Mesa. They had 900 ballots out of just 2,000. And then we had an LDS church, yes, the Mormons, in the heart of Tempe that had 60 out of 1,500. Says Jarrett describes the 19-inch image on a 20-inch paper as a fit-to-paper issue. Jarrett stated that the issue was, quote, due to our temporary technicians when they were trying to identify solutions on Election Day. Adjust a setting. So Jarrett's testimony implies that this issue was limited and was caused by techs, just technicians. But that's inconsistent. The investigative report has several inconsistencies. Jarrett testified that techs had made changes, but there were no troubleshooting changes made during the investigative testing. There are no settings that a tech or anyone could make on the printer to make randomized changes to a printer. If this is a purely random error caused internally by the printer, it's either a software bug or an extremely rare hardware issue. The bug would have been the most likelihood, but there are no bug fixes or patches listed by the vendor. A patch or a bug fix would most likely exist, and it would affect every printer. But the randomness still doesn't reveal why this would be happening. The only cause of this is erroneous code or malware or remote configuration changes. During his testimony, Scott Jarrett stated that the fit-to-print issue occurred because techs adjusted a printer setting while troubleshooting a, quote, speckled ballot. His testimony is inconsistent with other evidence, including McGregor's report, saying that printers randomly selected 19-inch ballots for unknown reasons at unpredictable times, at weird intervals with strange technical data, indicating that no settings or combinations of settings could have caused the change. The fit-to-print issue rose on Election Day, and it precludes the possibility that it changed from settings. 2 printers use different hardware and software. So the most likely cause is its software control external to all of the printers. That possibility was not investigated nor even considered by the McGregor team because they lack the expertise to dig in. Scott Jarrett's testimony also indicated that it was limited to just 3 locations. That's not true. The rates of occurrence say that 8,000 or more may have been impacted by the issue. For example, at Victory Church, they had issues. Here's a screenshot from the logs. Out of 15 ballots I looked at, 14 of them were the 19-inch. 93% were the wrong ballot size. They're also taking a look at various settings, saying the settings were incorrect. We got a bunch of printer error messages. The error rates were extremely high. He's showing you the charts. Maricopa County's claim that the late afternoon fixes resolved the issue is also incorrect. The graph below shows thousands of false paper jams lasting almost all day until 6:30. Look at this. 6:30 a.m. to 7 p.m. Polls open right here at 6 in the morning. People get off work at about, 5 o'clock. This is about 6 o'clock. So if you're going in to vote, if you're leaving work on the way home, if you're going on your lunch break, if you're just taking your day to go off, jammed up in this section. Then they fix it. Oh my gosh, everybody's going home for the evening and the votes are being counted and it's looking good. So it all starts, not a problem anymore. They get it fixed. Election day showed a widespread continuous pattern of insert failures. 7,000 insert failures every 30 minutes from 7 a.m. on. Here's what it looks like. Election day starts. Now imagine if you're Katie Hobbs and you're a Democrat and you're running for governor and Kari Lake is the Secretary of State in charge of running elections and something like this happens to you and all of your voters were supposed to be there on election day voting for you. And this is what it looks like. 30-minute intervals on election day. Count of ballot insert failures. Here's what it looks like. Look at this. Goes all the way up. 7,000. It's hovering around 7,000 on average, bumping up over 8,000 at some numbers. All day. And then it trickles back down at the conclusion. 71%, nearly 3/4, were involuntarily rejected using a threshold of misfeeds over 20%. 71% were involuntarily rejected. Extraordinarily high threshold. Absolutely nuts. So if this were anybody else, if this were any other election for a Democrat, there would be an absolute national meltdown over this being stolen away from the Democrats. But here, it's not even it's all, it's over. It's over already. All right. Stop crying about it, you conspiracy theorists. This was signed by Clay Parikh, and he will be the expert witness, hopefully, that we hear from next week, presuming that Kari Lake and her lawyers get permission to bring him in from the judge. And so that, my friends, is it for us on the day. We covered some good ground here. That was a major Kari Lake update. And as a reminder, Kari Lake is going to be back here for trial, and we're going to see what is in store for that next week. 3-day bench trial starting on Monday, May 17th. And so just like we were here today, we are planning on live streaming the whole trial. It should be 3 days, May 17th, 18th, and 19th. And so I do hope you join us. You're subscribing, you're liking this video, you're inviting a friend over to come and join us. It should be a full 3 days. And we'll be looking forward to seeing what happens here because Arizona is in many ways the tip of the spear. It's the tip of the iceberg. What happens here if Arizona turns blue and we don't get our election affairs figured out, it may make it a difficult place for the rest of the country to stay red. If Arizona falls and other cities and other states start to fall, could be a big problem. So we'll continue to cover. We appreciate you joining us as we jump into this case. Should be a very doozy of a trial, and we'll look forward to it. So now let's hear from you. What do you guys say about all of this and more? We had a lot of news, a lot of updates there. So let's jump over to YouTube. Let's jump over to Locals and Telegram and Twitter and see what is happening out there. And so we will not be back here for a live show later tonight. This will be the show for the day. And there was a lot to unpack here, but we will have member only after party here today. And we'll also have a members only stream tomorrow morning, which we do on Saturdays. And so if you would like to join us, come and join us over at watchingthewatchers.locals.com. And don't forget to grab the Telegram link if you are a new member on YouTube or on Locals. And before we jump into your comments, and I think somebody wants to take a look at the Amicus as well. And so Six Sponskys on Locals wants to jump into the Amicus. I'll pull open the Amicus as well, and we'll take a quick look at it. But let's talk about Field of Greens first, because we all would like to lose some of those leftover pandemic pounds. You know, it's summertime, it's swimsuit season. But we all are sick of the ads for the weight loss pills, the fad diets, but we'd all like to, you know, lighten up a little bit. But we've been there, we've done that, we've seen these other things don't work, but you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that, the weight would probably just fall right off. But look, fruits and vegetables, I know, not a fan. It takes a lot of work to prepare it every day. But don't worry about it. Instead, let's talk about Field of Greens, because Field of Greens is a very specific formula of fruits and vegetables that you're not going to find in any other product. Proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you'll look and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor says, wow, you've lost weight. Whatever you're doing, keep it up. And so let's get you started. Go on over to fieldofgreens.com. Save 15% off your first order with code Robert. It's fieldofgreens.com. The vegetables want to be eaten, and they've got a bunch of amazing stuff there. They've got stuff for general health, like Field of Greens, stuff to help you calm down and sleep, stuff to help you really get lean, stuff for your joints. A lot of great products, all real organic superfood. Just go over there and read the ingredients. If you just read the ingredients, you'd be like, okay, I guess I'll get some, because it's really good, and it tastes good. It's good going down. And the vegetables want to be eaten. So get your real organic superfood and start bursting with green energy yourself, the good kind. Also, if you want to get the mind map that we use here to navigate, you can get that over at spotlightlawyer.com/mindmap and sign up for a free account. So you too can navigate around and take what's in your mind and put it on paper. It's much better there than bouncing around the head all the time. All right, we had a couple super chats that came in on YouTube. Thank you to our YouTube friends. We had Voice of the People says, hey Rob, just where was that doc of why they wanted to oust Juror 77? Looked on the Spotlight Lawyer site and can't find the mind map section. The motion to oust, the Tim Pool juror. It's not on there. Let me put it on there. And let me throw it in Telegram. Voice, are you on Telegram? I'll throw that right in Telegram right now. It's the easiest way for me to share it. But I'm just dropping it there right now. So it's over there right now. But yeah, Tim Pool, Roberta Kaplan tried to throw out a juror for listening to Tim Pool. This was the actual filing, which was pretty funny. Here it is, Tim Pool. Yeah, we had a fun time with this one. Tim Pool's responsible for Hiroshima. Tim Pool caused COVID. Tim Pool, he's responsible for a lot of catastrophe in this world. It's clear he's biased, this juror. Why? Because he listens to an extreme right-wing podcaster who consistently and aggressively espouses prejudicial views. Such a joke. All right, so I dropped this motion on our Telegram. If you're a member, grab the Telegram. A juror who views Pool's podcast. No person capable of deciding this case fairly would seek out Pool's content. Gosh, we did a full video on that. So if you missed that, go back on the channel and take a look at it. It's hilarious. Tim Pool. Yeah, was he the bad guy in Avengers too? Did he wreck the whole universe? Here is intellectual iconoclasm. Is it perjury for them to make egregiously and patently false pleadings? Well, yeah. I mean, if it was, I don't think that anything that we've seen today meets that standard, but it wouldn't be, necessarily illegal. But if you're a lawyer and you are submitting motions in bad faith, there's all sorts of ethical problems. Like you've got a duty of candor, they could report you to the bar, but aggressive representation and being very, unless you're being dishonest and like openly dishonest, you can make arguments that are very aggressive in the law. And that's a good thing. We want more of that. We want an acceptability of it's the adversarial system. So we want people at each other's legal throats, so to speak, so that we can get a synthesis and get the best outcome. But unfortunately, I think what we've seen is that that's only really favored if you're a Democrat. You can only use the law in your favor. If you're Trump and you file a lawsuit, you're a conspiracy theorist trying to interfere with democracy, right? If you defend a due process or equal protection of the law for a J6 defendant, you're supporting insurrectionists. You're not fighting for the presumption of innocence. You see how this goes. So you're allowed to in the court of law make very aggressive arguments. Doesn't necessarily make it illegal. But good to see you, intellectual iconoclasm. Looks like you might have a nice YouTube channel over there too. Cool, good to see you. Naz is here, says there is a 7-minute clip of Democrats making the same claims in 2016 about the issues of voting that we're making now. Yeah, I'm pretty sure I have that somewhere. Here, let me see. Let me see if this is something that just pops up. In my list. Yeah, I think I have it right here.
You can run the best campaign.
Actually, yeah, that's the short one. Here's the 10-minute version.
You can run the best campaign.
Yeah, this is 10 minutes.
You can even become the nominee. And you can have the election stolen from you.
Yeah, 10 minutes. We're obviously not going to watch it all.
How can you win with Russian interference, though?
That's
That's
a real
what I'm
thing.
scared about in 2020.
But rightly.
Because I think he's an illegitimate president that didn't really win. So how do you fight against that?
Yeah, Trump's illegitimate.
You are absolutely right.
He's an illegitimate president in my mind.
Would you be my vice presidential candidate? Folks, look, I absolutely agree.
Trump didn't actually win the election in 2016. He lost the election, and he was put in office because the
Russians. Remember the Russian story? All the Russian story. It says Trump was a Putin stooge. Remember all that? Yeah, they did all of that, and no names being thrown at them. And I just dropped that video over on Telegram too. So members, you just grab that one too. So yeah, it's just nonsense. It's good to see that, Naz. And a bad poet says, "Hey, great work." Kari Lake says they need your help. Well, we're here in Arizona. We're going to try, we're going to work hard here in Arizona and try to keep Arizona red, over this next election, because this is a pretty important place. If Arizona goes blue, it makes the whole thing difficult. So yeah, we gotta definitely make sure we're amplifying the energy level. Steel Stargazer, what's up, Steel? Says, can you explain that guy on Cochise County saying he was certifying under duress? Thank you. Yeah, but I think that's mostly gotten resolved, right? That was in the Abe Amade lawsuit, which I have not been covering as much. Let me see if I can grab on that. So there's a different county here. Cochise County is a different county in Arizona, much smaller county, not Maricopa. So we're in Maricopa County Superior Court with Kari Lake stuff. Cochise County is a smaller county, beautiful county, and a lot of great places to go up there. But there was one person who is on the board there who said he's certified under duress, and I think, yeah, here's an article over from Hot Air. This was a summation of it. Let's see. 2 members of Mojave voted to certify under duress, they say. I vote aye, but under duress. Says, I have no choice, otherwise I'd be charged with a felony. Says Ron Gould, Hildy Angius also expressed reservations, but certified the results anyways. She pointed out that her concerns were not for Mojave, more upset over Maricopa County being the laughingstock of the world. Cochise County is being sued for not certifying the vote by the deadline. Katie Hobbs sued the county. Similar to Mojave, Cochise is not suggesting their results are in question. They just preferred to wait until all the bugs are worked out in Maricopa. So, yeah, so that's about as much as I know on it. I don't know how much further the litigation has gone, if at all. But Good question. And thanks for the super chat over there, Steel Stargazer. I appreciate you on that one. Okay, let's say hello. We have Jigam Geegum. Jigam Geegum is over on Locals, and let's say hello to Locals. Locals, we're about to expire in about 5 minutes, so I'll open up a new thread. But Jigam is in the house, and what is Jigam saying? Jigam's one of our amazing meme smiths. Says, so what do you think will take to ensure an honest election in 2024? Republican lawyers, where'd that go? Republican lawyers becoming judges, succumbing to early voting. Thanks for covering, Rob. Jigam, I think, yeah, I mean, I think it's all of the above. I think that all of the stops need to be pulled out. Everybody absolutely has to vote. Everybody should be dragging 2 people with them to vote. I would like to see some sort of, Republican conservative effort to bring 2 people with you to vote. Everybody's responsible for 2 people. Did you vote? Did you vote? Be that person this election. Like, I'm confirming that you voted, right? Okay. We just got to do that. And I think that, a massive response. If the GOP needs to get involved, right, more so than they did in 2020, I think that they were perfectly okay sitting on the sidelines and watching Trump fall. But lawyers, litigation, the Democrats had a ton of legal heavyweights in the game in 2020. We covered a ton of those lawsuits. So I think early voting's fine. I think that, an early vote is better than a no vote. An early vote is better than an election day vote that doesn't get counted because of election day shenanigans, right? It's numbers. It's masses of numbers, and everybody's got to be dragging somebody to the polls with them. It's just how it goes. And I think lawyers would be involved. Money's going to be involved. Oversight's going to be involved. Going down there and watching the polls, stuff like that. I think it's all going to be very important. And thank you, Jigan, for the tips and all of the amazing memes over on Locals. What else do we have? Let's take a look at Twitter. Let's take a look at Rumble. We had a busy Rumble today. Thanks, everybody, for jumping in and watching us on Rumble. Man, we got a full house on Rumble. It's good to see everybody. We've got Frank Quarters is over there. List News. KBZ's here. We've got Nug Monster. We got another one from Madman. Ultra users in the house. Shout out to all of our Rumble friends. We appreciate you guys watching and subscribing on Rumble. And hey, we had a couple tips come in. Alan Harkin. What's up, Alan? Alan said the following. Says, I absolutely adore and admire Kari Lake. She's pretty awesome. I also admire Robert. Well, that's nice. For consistently having the drive and the desire to educate and inform those of us who need remedial guidance through legal issues. Well, Alan, that's a nice compliment. Thanks, brother. I appreciate you saying that. And I appreciate you being here. And you know what? I'm also getting a legal education as we go through this together. We're all figuring this out together and trying to make sense of it. And these are a lot of new and novel issues. I can't tell you that anybody has experience with a former president being indicted in a New York City court. It's never happened before. So we're all going through it. We're all feeling our way through it. And we're trying to have some fun while we do it and stay positive and remember that we're on the side of freedom. We're on the side of liberty. And these are things that are progress in the universe. The other side, which is censorship, silencing, and trying to have personal autonomy stripped away from you so that it can be gobbled up by some power-hungry bureaucrat somewhere, that is the losing side. So even though we go through these ebbs and flows and these ups and downs and these gives and takes, we're on the right side of history. We're learning all of these things. We're having some fun. And we're seeing how it unfolds and in our little way, trying to be a part of a better outcome by being a part of the conversation that is useful. And when the time comes, by dragging people to go and vote, as frustrating and as futile as sometimes it may seem, it's what we've got. We got to go do it. And our society, our humanity, our species has come way too far in this world to just give up on the principles of the Enlightenment. We cannot allow that to happen. Most of human society has been mostly misery and slavery and anti-free speech and royal class versus the peasantry and all of these things. And we've now got our hands on the concept of free speech and the concept of presumption of innocence and the concept of individual sovereignty and a limited government and all of these things. And we are not going to give that up, man. We are not. And so we got to get active. We got to turn the political volume up, the peaceful volume up, to go in and be a part of it. And so Kari Lake is doing it, man. She's in court. She's fighting and fighting and fighting. A lot of other people could have just given up. And so, Alan, I appreciate you being here, and I appreciate you being here, everybody, for joining us as we continue to cover this stuff. And we certainly will. And there will be a lot more to come. We're just getting warmed up, man. And there is just a whole lot of stuff that we think is coming down the pike, in particular with Donald Trump. So thank you to our friends over on Rumble for those great messages and for jumping in the chat. What's going on Twitter? Let's see what's up over on Twitter. And hey, locals, hang tight. I got to pause. Locals, we're opening up another thread right now because we get timed out over there. So we're opening this one up as we speak. And it looks like we are now live. Okay, so we're back in business over on Locals in part 2. And let's see what's happening on Twitter. We've got 8 people watching on Twitter. And, you know, my Twitter feed, yeah, so the Twitter, oh, here it is. Yeah, here it is. Okay, who's here? We got Josh Barnett, former Arizona 1 candidate in the house. What's up, Josh? Thanks for stopping by. We've got Omnipotent Being, says, bursting with energy and anticipation. Good to see you, Omnipotent. We have this one from 881221, says, caught alive. We'll be listening on Spotify during work, though, since I work nights. Here to add to the Twitter numbers. Well, thank you, and thank you, everybody. And I always forget to like. And you know, if you're on Twitter, this is a great way to sort of connect with other watchers on Twitter. Sometimes you get on a new social media platform, and you're like, it's so lonely out here. Where is everybody? But hey, hop on to the thread, hop onto the Twitter thread, give everybody in this thread a follow. And when we're here, when the show's going on, get to know each other in the Twitter threads. And hey, you know, follow each other, drop comments on each other, and then Twitter's a little bit more enjoyable when you're out there because you can comment on somebody else's stuff, follow them, see what they're talking about. And we stay connected. Community is very important. My comment says, Blem talks a lot better in court than the motions that get written from the lakeside. Thanks for explaining the motions. They don't read fluently, so you can visualize what the issue is. It says, box 3 was oversold as a redundancy. Yeah, that was that separate box. That you put your thing in. One of the silver linings in this cloud was that at no point was any voter in Maricopa County unable to vote starting at 6 o'clock. That's why the vote centers were important, he said. Yeah, good comments there. Good comments there from my comment for Steele. And those are our friends on Twitter. And so we appreciate everybody over there. We had another comment from GSD Lady on YouTube. I'm sorry, on Locals. Says, this is why I worked the polls the last election. I am a relatively conservative part of upstate New York, and we use those same effing machines, and there's so much room for effery. If I had not been working at the voting tabulator center, it would have been much worse, but they set it up to have issues from the start, from GSD Lady. And that's good to see you over there, GSD. Okay, now somebody wanted to take a look at the amicus, and let's do that because we can grab that. It's going to be pretty quick, but this is the list of all the filings and the motion for leave to file the amicus. Now, this is being filed on behalf of Kari Lake. And so let's see what they submitted here. Starting at the top, this was David Mast. So let's get our red pen out and see what they are alleging. Now, an amicus, this is a friend of the court. So they're not a party to this case. They're just saying, I've got an interest in it. And we see this all the time in Supreme Court cases. Every time there's a major constitutional issue, you'll see, you know, the ACLU files an amicus brief. And why is that? Are they involved in the litigation? No. but they just are involved in ACLU things, and they'll submit an amicus. So this comes out from Ryan Heath. He's an Arizona lawyer. Shout out to Ryan, along with Alexander Haberbush. He's from California. This is a brief of amicus in support of Kari Lake's contest. So it's pro-Lake. Now, David Mast, so the lawyer Ryan Heath is filing this on behalf of David Mast. Who is David Mast? He's an Arizona voter. Shout out to David Mast. He's got a strong interest in ensuring the outcome of elections as being free and fair. So do we. Table of contents telling us what they're talking about. He says, the eyes of the nation are upon this honorable court. It's true. This case squarely presents the question of whether state laws that govern elections mean what they say, or whether they are meaningless guides to be tossed aside out of convenience. In this case, the court must apply the law and strike all votes from Maricopa County in the gubernatorial race. This is so even though Ms. Hobbs has been sworn in as the, quote, governor because of the wrongdoing of the Maricopa County defendants. Relief here is requested by Kari Lake. It's supported by over a century of clear precedent. If this court fails to apply the law, it condones clear acts of mischief, errors, omissions, and gross negligence, and thereby invites acts of similar misconduct in the future. For the sake of this nation, amicus David Mast respectfully requests this court apply Arizona election laws, follow binding precedent, set aside the results from Maricopa County's governor's election. So this is an interesting filing. I like how it is written. The Arizona Supreme Court ruled that Count 3 was not barred by latches, saying you can relitigate this claim. And they're saying Ms. Lake has actually shown more than's necessary. And so definitely rule in favor on her Count 3 as a matter of law. They talk about the standard competent mathematical basis, saying she only need to demonstrate that the number of improperly verified ballots exceeds the margin of victory. That's it. And they say she's got evidence from 3 testimonies with knowledge of the rejection, saying that the court can now conclude as a matter of law that they tabulated these things illegally. The math is straightforward, enough so that even attorneys can understand. I told you, we're all bad at math, all of us, me in particular. Attached to Miss Lake's complaint are 3 affidavits. These witnesses have testified. They say that they saw what they saw with rejection rates in 25 to 40% range. And so this is all on behalf of David Mast. This is good stuff, but as we saw, the judge may not allow any of it in. We'll see. And it's a very large filing, 318 pages. So I'm going to guess, yeah, the actual motion's not all that long, 13 pages. But the rest of the filing is the brief that they submitted to the Court of Appeals. And so they've been involved in this case for quite some time. It's curious. I'm curious who or what prompted this. I mean, other than wanting to see your state not get wrecked and ripped away from you. But shout out to these individuals who are jumping into this fray. This is the type of stuff that I think we need more of on the right. Okay, like a lot more litigation. So shout out to all of these lawyers who are putting their hat in the ring. Shout out to David Mast, who is probably funding this litigation. And it's all perfectly acceptable. And the Democrats do this times 1,000. And they've got full legal teams. Perkins Coie is representing Katie Hobbs, I believe, or somebody on that government. And that's the same law firm that we've talked a lot about here. So, all right. So that is the update on the amicus. And I think, my friends, that is about it for us on the day. And so we are going over to our members only after party. Let me check over on Telegram. Oh, yesterday. Hey, if Brenda Price is out there, Brenda, we missed you yesterday. Brenda sent in this super chat, says, I love it here. Well, we love you too, Brenda. I'm sorry we missed your super chat. What a total punk I am. Says, how do I join? Ask E. Gene podcast is very telling and skanky, which is true. But it is, Brenda, you can join on YouTube. You can click the join button right on your home screen. You'll join as a member and you'll get access to our members only morning live stream. We'll do a Saturday show tomorrow and you can join in on that. Or you can join us at Watching the Watchers www.locals.com, which is this address, which is where we're going over to our after party. We hang out after the show's over and debrief. It's a little bit, a little bit more casual. And we'd love it if you joined us watching the Watchers. .locals.com. We have a brand new stream over there. So we're still going over there. We also want to say, get your field of greens, my friends. It's a great way to be healthy and nutritious and be fortified. We've got a lot of bad food out there. We've got a lot of bad news out there. We've got a lot of stressors in our life. Something we can do, take care of our bodies, get your daily servings of fruits and vegetables, eat it, get it out of the way. You're done for the day. Fieldofgreens.com, save 15% with code Robert. And remember, the vegetables want to be eaten. I want to say thank you to our mods, and our moms, and our meme smiths who mod down the fort for us and keep things nice and orderly. We've got Vienticus Prime here. We've got K Bean. Shout out to Just Cause, Playin' Hooky, Ronnie Cole, our friend Zulu, Geomancy, Zach Nichols, John Allen, Janek, Dog Digger, and Donut Mind Me, all modding down the fort for us. And we've got the best mods. We love our mod squad so much, and we appreciate you guys. Sleepy Dog Lee is here along with Geegum Geegum in the house. We appreciate everybody who helps to keep this show on the tracks. And we are looking forward to being back here next week to do it all again, because Monday is going to be full. And then we've got Kari Lake trial next week, and so that's going to be full. And so I hope, my friends, that you have yourselves a beautiful weekend, that you're able to unplug a little bit, recharge those batteries, rejuvenate that energy level, because we're going to be back here to do it all again. And if you're a member, we'll have a Saturday headline show, so come and join us, whether it's on YouTube or on Telegram. We'll look forward to seeing you there tomorrow morning. Otherwise, everybody, it's Friday. I hope you're having a beautiful close to your week. I'll look forward to seeing you right back here on Monday, so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful weekend, my friends. I'll see you right back here on Monday. Bye-bye.